Welcome to our EIB meeting. It's on February 29th, 2024. It is 9:04. And so, Ms. Jones, in order to start off our meeting, would you please do a roll call to document who's here this morning? Yes. Good morning. Member Bitzer, are you present?
Present.
Member Ely? Present. Member Garcia? Here. Member Honker?
Here.
Vice Chair Trujillo? Here. Chair Sweeney? Here. Everybody's in place, Chair Sweeney. Thank you so much, Ms. Jones. With that, we'll go to agenda item number 2, which is the approval of the February 29th, 2024 agenda. Are there any suggested revisions to the agenda? Yes, Member Hoffer?
Question, we got a request for a stay or extension on the public hearing that's on the agenda today, EIB 2375, on the radiation fee amendments. And as I read it, the request dealt with the materials we got late in the day yesterday for NAB. I'm kind of seeing two options. If we switch the order of these public hearings and do 2359 first, it would give parties more chance to review the materials from 2375 that came in recently. Another option would be to extend a comment period on 2375 after the hearing today. So I wanted to throw those out and see if the parties on 2375 have any comments on either one of those in terms of resolving that issue.
Thank you, Member Honker, for that discussion item, and I want to look to our legal counsel. How would you, will we just allow the folks that voice the motion to speak on this, since we're still on the agenda item? This may determine and be part of the discussion in terms of our approval on item number 2. Is that okay? Yeah. Okay. So I look to the virtual platform, and I think I see Mr. Maxwell.
It's limited to whether I have an objection to whether you're number items 6 and 7 to 11. If they do, then they want to consider it.
Okay. So Mr. Maxwell, what we would like to hear from you, and Member Hunker's discussion this morning on agenda item number 2 in terms of our agenda. We would like to hear just specifically your comment or feel about flipping the agenda items, which is public hearing 2375 with 2359. If you would, if that's something you would consider to address some of what you shared via your motion this morning.
Can you hear me?
Yes.
Thank you for giving consideration to what I've put forward, and I would be friendly towards that. I would appreciate that very much so, or any kind of solution that offers more time.
Thank you so much for that input, Mr. Maxwell. And I want to look to council for NBD and your thoughts on that. I believe Ms. Chai is here. Yes, would you mind coming? Speaker, thank you.
Good morning, Jesse, members of the
She's not tested. Party positions.
NMB's position about switching the order, 2359 and 2375, is that we would be amenable to that.
Thank you, Ms. Chai, I appreciate that. So with that information, Member Humper?
Well, then I would propose that we revise the agenda for today and switch items 6 and 7. Do the EIB 2359 public hearing first and the 2375 after it.
Thank you, Member Hunter. With that, so that's
Smoke.
motion, okay.
Like that.
Thank you, Member Bitzer. So we have a motion on the floor and a second. Is there any further discussion? If not, Ms. Jones, would you please take roll call vote on Member Hunter's motion?
I will. Mr. Bitzer, how do you vote?
Vote yes.
Member Ely,
Yes.
Member Garcia,
Yes.
Member Hunker,
Yes.
Chair Sweeney,
Yes.
Vice Chair Trujillo.
Yes.
The motion passes.
Thank you so much. All right, so we switched that. I think we had a full approval. Right? Except we had a full copy here. Okay, so we'll go on to agenda item number 3, approval of December 15th, 2023 regular meeting minutes. Oh,
Request for the agenda.
okay. Oh, sorry. Okay. Yes, we have another request or discussion on that agenda before we go to agenda item number 3. Yes.
So I'm,
Could you share it with us, just
who I am,
who you are?
and this is on.
Yeah, push the button.
Push the button.
So hi, Chair Sina and members of the board. I'm Regan Scott, and I'm an assistant general counsel for NMED as well. And so I'm requesting a correction / clarification to item number 5 on the agenda to be more clear that this motion is not being substantively argued or determined today. That it's I'm not really sure what is being discussed for this item, but to be more clear that it's not.
Thank you for that. And thank you for that comment. I understand. So legal counsel, should we do that when we in the agenda documentation? Or should we do it when the agenda item?
Well, if we're gonna do an amendment of the agenda, it's gonna do it now. The rule is pretty clear that this item can't be substantively heard until 60 days after the motion has been filed. The board is just going to discuss whether or not they appoint a hearing officer. If you would like for your benefit for us to add discussion only of hearing officer,
Or discussion of procedural
procedural matters.
Thank you for that.
So let's, if someone would like to make a
Yes.
motion.
So members, just to provide further clarification, as legal counsel shared with us, is that we there's a 60-day waiting after the item comes to the motion comes to our attention. And so what we will be discussing is more procedural, not the motion itself. And so I think legal counsel from NMED, and correct me if I'm wrong, would just like for the clarification that we are not looking at the motion itself. We're just looking at the procedure so that we can discuss the motion at the later date. So if there's any questions on that before a motion to make further clarification in order to propose a motion. Yes, yes.
So the board
Clearly not
Muted.
whether to grant,
Wow, okay. So the board,
People, you're gonna turn your microphone.
I did turn it, didn't I?
oh, circle.
Sorry. So I don't get an echo, but can people hear me?
Not very much.
So the board. It's muted.
Is the sound?
Turn the volume. a little.
Someone online.
Yeah.
Oh, okay. So-
Suggestion.
Okay. I'm on.
Okay. How about now? There we go. Yay. Technical difficulties. So this item is to discuss the process around the stay, not whether to hold a hearing on the stay or not.
Correct. There will be a hearing.
There will be. So the board can't make a decision on whether to hold a hearing or
Well,
not. It's automatic.
You can make a decision on whether to hold a hearing.
Oh, we can.
You can also decide if you don't want to hold one.
Okay.
As of right now, the next time that a hearing would be held would be March 22nd, which is your next board meeting.
Okay. I just my
I think
recollection.
get into this more so
Okay.
also during the actual agenda item. I had just proposed that we discuss whether or not you folks wanted to have a hearing officer, which is kind of out of the norm for
Yeah.
motions per se, but
I just recall before the board made a decision on whether to even have a hearing on the stay. Not. Yeah, okay, great. So that's what I needed to know.
Thank you for the discussion point, member Ely, and the point of clarification. I appreciate that because I think we're just trying to figure out how we can make sure we have clarity on the agenda item and also for the public where we are and the various parties associated with this particular item. With that additional discussion, is there any further discussion prior to a motion? If not, I'm looking for a motion to move on. And if there's further questions, be happy to discuss that prior to anyone making a motion.
That tells me not everybody's real sure.
Yeah.
What it should be. And I'll tell you,
Sure.
I cannot hear some of you guys over there at that end.
Oh,
Not very well, so if you speak into the microphone, that'd be better. Also, I imagine those folks are not hearing you all that well either.
from what if I may help clarify from what I'm hearing, I think just the simple phrase procedural consideration only as language added to that agenda item might be helpful. So if anyone wants to make a motion just to eliminate that specific agenda item to include the phrase procedural discussion only.
thanks. Thank you. Yes, member Garcia.
Thank you, Madam Chair. I'd like to make a motion that for agenda item number 5, that it is a procedural, it is a procedural matter that we will be discussing, not the motion for stay.
I'll second that.
Thank you, member Garcia. And for your motion, and member Fritzer, is there any further discussion? I'll get a motion on the floor. Member
No,
Ely?
I just, so the wording in the agenda would be in the procedural that way. Never mind. I vote for what Karen said.
Thank you, member Ely. So the motion on the floor is for agenda item 5, EIB 23-56. That it's a discussion on the procedure for in the matter of proposed amendments to and the rest. That is it.
Yeah.
Member Fox. Right, any further discussion? Clarification? If not, Ms. Jones, please do a roll call vote on Member Garcia's motion.
Member Bitzer, how do you vote?
I'll vote yes.
And Member Ely,
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo. Yes. Chair Sweeney,
Yes.
motion passes.
Thank you, Ms. Jones. Appreciate it. With that, I believe we can go on to those amendments, one through Member Honker's revisions, and then the second amendment to the agenda through Member Garcia's motion. We have an agenda for approval of the agenda now. And so just for clarity, so we make sure we have it on the record, I would love to look to our board members to do a full agenda approval with those two motions that, to incorporate the two motions. Yes, Member Hunter?
Yes, I move we approve the agenda as modified by the two motions that we just voted on.
I'll second that.
Thank you, Member Hunter, and Member Bitzer for your second. Around, no further discussion on the motion. Ms. Jones, would you please do a roll call vote on this motion?
Member Ely, how do you vote?
Yes.
Member Bitzer,
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo. Yes. Chair Sweeney,
Yes.
motion passes.
Thank you, Ms. Jones. With that, we go on to agenda item number 3, approval of December 15th, 2023 regular meeting minutes. And with that, yes, Member Ely?
That we approve the December 15th, 2023 regular meeting minutes.
Thank you. I second that. Thank you, Member Garcia, for your second. Any further discussion, any revisions that any board members see? See any? With that, Ms. Jones, would you please do a roll call vote on Member Ely's motion?
Yes, the motion to accept the minutes. Member Bitzer, your vote,
I vote yes.
and Member Ely,
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo.
Yes.
Chair Sweeney,
Yes.
motion passes.
Thank you, Ms. Jones. With that, we'll go to agenda item number 4, which is public comment. And these would be general comments not pertaining to any meeting agenda items that we have on our agenda for today. Looking around the room, see any here on the platform? Didn't see anybody raising their hand. Give you 10 more seconds. Making sure nobody wants to do public comment. Has anybody reached out to you, Ms. Jones or Ms. Farney?
No, I've received no request to make public comment this morning.
Okay. With that, we'll go on to our next agenda item since there's nobody raising their hand for public comment.
You got one?
Oh, I do. Okay, we do have one. So for public comment, I'd like to keep it to 2 minutes. And I can't, there's no name on there.
Pete.
Oh, Pete.
Good morning, Madam Chair, members, Pete Domenici. I was just raising my hand for the next agenda item, just to let you know I'm here when you get to the next one. Thank you.
Thank you, Mr. Domenici. Appreciate that. With that, we will go on to the next agenda item, which is agenda item number 5. And that is EIB 23-56. And this is to discuss the procedural considerations for in the matter of proposed amendments to 20.2.91 and that. the New Mexico Motor Vehicle Emission Standards. And this is regarding a motion for stay submitted by. And so we do have Mr. Domenici on the platform. Mr. Domenici, you have the floor. Before you start, Mr. Domenici, we'll have our legal counsel clarify a point.
So this is on, as noted earlier, this is on the agenda not to discuss the merits of the stay. As everyone is well aware, the rules governing the motion for stay require a 60-day waiting period from the time that it was filed, so the board is precluded from hearing the merits today. That being said, we wanted this on the agenda to discuss the possibility of appointing a hearing officer. Although in the past, this board has heard motions for stay without a hearing officer, this is a particularly contentious issue. I also recall the last motion for stay, it got a little heated. And so a hearing officer could be beneficial in ensuring that all of the parties are heard. I've also noted that there have been some parties in this particular matter who have made some rather weighty accusations regarding this board, its transparency and its ethics, which were both unfounded and concerning. However, that being said, I think it's most important for everyone to feel that they're having a fair hearing, that they're being heard by an unbiased party, and that we should do everything in our power to make sure that everyone gets a fair shake. So out of an abundance of caution, I think it could be helpful to have a hearing officer. Fortunately, Felicia Orth, who presided over this merit part of this particular matter, has also stated that she would be available on that March 22nd date if you folks so choose to vote for that.
Thank you, legal counsel.
I also had, I had a few questions for Council Domenici, which is why it was placed on the agenda as well, particularly pertaining to how long he believes his presentation will be so that we can plan accordingly. So the board can plan accordingly, whether there will be witnesses called or other interested parties. I understand that Mr. Domenici represents several of the parties, and so I want to confirm that he will be the only one presenting, or if there will be other attorneys presenting, and then we can plan accordingly. Thank you.
Thank you, legal counsel. With that, looking around, Mr. Domenici, are you still?
Yes, I am. Can you hear me?
Yes, yes. So, yes, and the floor is yours. I would also like to hear the response to some of the questions that legal counsel had as well.
I would expect that our presentation would take about 90 minutes. There would be an opening statement and witness testimony. So I think the opening and closing statement combined would be 30 to 45 minutes, and the direct testimony of 3 to 4 witnesses would be the rest of that 90 minutes, either 45 minutes or an hour. I'm planning to present everything. I do represent 2 different parties. If another council would assist me, they would be within that same time limit that I just described.
Thank you, Mr. Domenici, for answering some of the questions that were raised this morning. I have one follow-up. Is there a way, so just so that we can plan and make sure ahead of time that a witness list could be provided as well to the board?
Yes, I'm fine with that. Just let me know the timeline for that. We'll certainly comply with the witness list.
Okay, thank you so much. And as we discuss the procedural, this helps us with our discussion on the process and the logistics of that. And as we go through that, we'll make sure that we address the timeline of the requested submittal of witnesses. Is there
Thank you.
anything?
Yep, I'm available if there's any other questions.
Okay,
Thank you.
thank you, Mr. Domenici. Appreciate it. So, and I know I see legal counsel for NMED here as well, and so would like to hear from you on this agenda item.
Sure, Chair Serena, members of the board, Brian Scott for NMED again. So I just want to back up a few steps that, in general, the board can decide whether or not to hear this matter, just as a baseline issue. And then the other item, the time period that my understanding was is that from the time a motion for stay is filed, that it can't be heard before 30 days has elapsed. And so you're still, if you choose to hear this matter on the 22nd, March 22nd, you're still leaving that 30-day time period elapsing. But I think, it's helpful to hear potentially the amount of time and to hear, for just logistics purposes of that meeting that could be. But I think what we would request is that the actual time limits and witnesses, identification of witnesses, that all of that be, that we would ask that be reserved to be fleshed out more in a more detailed manner in a pre-hearing scheduling order. If you so choose to hire a hearing officer, which we would not be opposed to, but that we reserve sort of the details of how that meeting really is structured and what each of the parties have in terms of time being included in that beginning.
Thank you. Appreciate that input. Members of the board, do you have any other questions? Yes, member Ely?
Just clarification, as NMED noted, we can make a decision today not for the hearing if we don't want to. And I think we should eventually have a vote on them, just so that if we decide not to go to hearing, the effort is made by all parties to pull together their testimony.
Thank you, member Ely. Is there any other thoughts, questions, comments of board members on this? Yes, Vice Chair Trujillo.
It was just a point of clarification, following member E's question. Okay, it was just a point of clarification following member Ely's question. We're not making a decision on going to hearing, we're making a decision on hearing the motion to stay, right?
My understanding is that we could make a motion, or we could, as member Ely said, whether we even consider the motion.
Oh, yes. Okay.
Is that a better way of framing it?
Yeah.
Okay.
I understand. Thank you.
Ms. Bowen?
Yeah, so if the board doesn't make a decision in 60 days, and I called them this earlier, then you'll have deemed to have denied the motion for stay. So you could technically take no action and not have a hearing on this matter. So choose. And that is what you can vote on that today. And then if you choose to have a hearing, you can also vote on whether or not to have a hearing officer who would then have a pre-hearing conference and make sure that a scheduling order is placed so that all parties are aware when things can be filed and to give the board ample time as well as the parties ample time to prepare for you. Okay, that's what I was thinking. I just wanted to make sure I got it right. Thank you.
Thank you, Vice Chair Trujillo. And again, this is very helpful, again, for transparency. So Ms. Bowen shared earlier, we know that there's been a lot of various viewpoints and diverse viewpoints on this particular matter. And so we want to make sure that we handle all of the comments and viewpoints accordingly and appropriately. So I do also appreciate the clarification. And thank you, Member Ely, for pointing out, the various options that on the table as well. With that, Member Ely?
Just one more procedural question. If the board decides not to act on the motion and not to have a hearing on the stay, then Mundo and Nemeda could then file to the Court of Appeals. That would be the next step. And are they required to go through the board on the stay before they go to the Court of Appeals? Is this a required procedural matter for them?
And I'll have to double check with the Court of Appeals filing rules. It is very standard. I don't know that it's a prerequisite for their filing. It is also something that will come up on appeal. It will certainly come up on. Thank you.
Thank you, Ms. Bowman. Member Garcia.
Thank you, Madam Chair, and thank you, Member Ely, for bringing that up. I have a similar question as far as the procedures. So my understanding is, and I believe I did read it in the rules that they are required to come before the board before Court of Appeals. So I understand this stay motion would be presented before the Court of Appeals in great detail, exhaustively, and they would rule on whether or not a stay is appropriate. So, so then the question becomes, do we need to hear it as well? If we were to grant the stay, then I guess they don't need to go to the Court of Appeals to ask for a stay because we've already granted, I presume. If we decide not to hear it, they would go before the Court of Appeals and present their case for a stay there. So that's my understanding of how this would play out.
Thank you, Member Garcia. Ms. Bowman.
And I just want to clarify too, this case is already in the Court of Appeals. It's been filed. So yes, to your point, if the stay is granted by this board, then it doesn't also need to be granted by, won't also be requested in the Court of Appeals. But that case, the underlying case will move forward.
Thank you for those points of clarification. Is there any further discussion? Comments, Member Humphrey?
Yeah, just for clarification, since I did not participate in the hearing and the decision making on this item, I'm going to recuse myself from any further decisions on EIB 2356.
Thank you, Member Humphrey, for that point of clarification. Appreciate it. So, any other questions or comments? All right. Oh, yes, Mr. Domenici.
I just wanted to encourage the board to hold the hearing on the stay. I think you heard the record of the hearing. That's why the rules require us to go first through the board and then, if necessary, to the Court of Appeals. And I think the issues at the stay are part of what was heard at the hearing. They're narrower, and then the irreparable harm portion really was not subject of the hearing, and that would be the focal point of most of our witness testimony. Of that 90 minutes that I described would be to assure we are allowed time to build a record on irreparable harm. Thank you.
Thank you, Mr. Domenici. Legal counsel for NVD, do you have any other comments?
How many other? Yes.
Thank you. With that, members of the board, I hope that helps illuminate what we have on this agenda item to discuss and decide upon. As legal counsel go in and as we talked about procedures, records. Just one thing from my point of view, want to make sure that we do what's appropriate, have good records and considerations on the documentation, And so that's kind of where I'm looking at this morning, just wanting to make sure we follow processes and we do it appropriately, so that we can continue to move this process forward. Member Garcia.
Thank you, Madam Chair. And I think in the spirit of our board usually erring on the side of, hearing from the public, hearing from the parties, allowing them to have their say, I would put forward a motion that we have a hearing on this EIB 23-56 for motion to stay.
Thank you, Member Garcia. Yes, Vice Chair.
I'll second that. Was that a motion?
Yes.
Yes.
Member Bitzer seconds and Vice Chair Trujillo.
Thank you. I was going to also support Member Garcia's sentiment. I think that this is an important issue, and for just completion of the record and documentation as it moves forward, then I think we should go ahead and have a hearing as well.
Thank you, Vice Chair Trujillo. Any other members? Member Ely?
I'll be able to amend that motion to include a hearing officer, the information.
And it sounds like,
Felicia is.
thank you, Member Ely,
Yes.
for that discussion. And I look to Member Garcia.
Yes, thank you, Member Ely. That's a great point. I amend my motion to hold a hearing on EIB 23-56 on March 22nd and have Felicia Orth as our hearing officer. That hearing on the motion to stay.
I'll second that amended motion.
Thank you, Member Bitzer, for your second to Member Garcia's motion. And legal counsel, I see Mr. Dominic has his hand up. Is it appropriate, or because we're now in the motion?
Yeah, then let's.
Okay. Okay, we will, yeah, okay, it's taken down. So we have a motion on the floor. Any other comments, questions? I do have one. Do we have to, at this point in the motion, just motion for a new, for a hearing without firming up like deadlines, dates, pre-trial? We can do that later.
Yeah, we'll have to agree to the hearing officer sheet.
Okay, I just want that point of clarification for the public as well as myself. So we have a motion on the floor. Is there any further discussion, comments? If not, Ms. Jones, would you please do a roll call vote on Member Garcia's motion?
Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia? Yes. Member Hawker?
Recused.
Vice Chair Trujillo?
Yes.
Member Chair Spina?
Yes.
Motion passes. One recusal.
Thank you, Ms. Jones. Appreciate that. Thank you, legal counsel, and thank you, Mr. Dominici. Appreciate you being here this morning on agenda item number 5. With that, at this point, we've been going for a while, and then we're going to get into our hearing. So we're going to take a quick 5-minute break here, and then we'll get on to our next agenda items. Thank you. Okay, back on from our break.
Excuse me.
Yes. All right. Thank you so much. We're back from break, and it is 9:53. Took about 3 more minutes after our break. Appreciate everybody coming back. It looks like all the parties are here. With that, I'm understand. I know we have to switch on our meeting agenda items, so we will actually be on EIB 23-59, which is a public hearing in the light of proposed amendments to 20.3.4.404 NMAC, 20.3.4.455 NMAC, and 23.3.5.15 NMAC, and 20.3.12.13 NMAC, and 20.3.15.1519 NMAC. And at this point, our fellow board member, Member Garcia, has stepped up to be our hearing officer for this agenda item. So I will be turning it over to our hearing officer Garcia for this item.
Thank you, Madam Chair. This hearing will please come to order. Today is Thursday, February 29th, 2024. The time is 9:54. My name is Karen Garcia. I have been designated by the board to serve as hearing officer, and I will be advised by the board's counsel from the Office of the Attorney General, Emily Bowen. May we have a roll call of the board, please? Ms. Jones.
Yes. Member Bitzer, are you present?
I am, yes.
Member Ely? Present. Member Hawker?
Present.
Member Sweeney?
Present.
Member Trujillo?
Present.
And Hearing Officer Garcia?
Here.
All present.
Thank you, Ms. Jones. Okay, so this is a hearing in EIB 23-59R to consider the, can everybody hear me okay? This hearing is EIB 23-59R to consider the proposed amendments to 20.3.4.404 NMAC, 20.3.4.455 NMAC, 20.3.5.15 NMAC, 20.3.12.13 NMAC, and 20.1.1.306 NMAC. This hearing allows for participation via conference, telephone, or other similar device, given all participants are able to hear. If there are technical difficulties at any time during the hearing, please bring them to my attention and efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environment Department Radiation Protection Bureau. Nicholas R. Maxwell filed a notice of appearance and is a party to this proceeding, but did not file a notice of intent to present technical testimony. Nicholas Maxwell will not offer any technical witnesses. There will be a designated time for any member of the general public to present non-technical testimony. This hearing will be conducted in accordance with the Open Meetings Act, the State Rules Act, the Environmental Improvement Act, and the board's rulemaking procedures. This hearing is being recorded by Cheryl Levine from Albuquerque Court Reporting Services. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing. Copies of the proposed amendments have been available on the department's website and at the department's office, as well as to interested parties upon request. The hearing will be conducted in a fair and impartial manner to assure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask that all persons at this hearing please silence their cell phones. If appearing virtually, please be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. Board staff will present pre-filed exhibits. Exhibits admitted into evidence are available for review by the public. All testimony will be taken under oath. As hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Any person offering an exhibit shall provide an original to the board administrator and a copy to each of the board members and to its legal counsel, and shall also provide additional copies for persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Petitioner will present its direct testimony on the proposed amendments, and petitioner's witness will stand for cross-examination by Nicholas Maxwell, the board, and any other person in attendance who wishes. Nicholas Maxwell will then have an opportunity to present an opening statement. If any other persons, including members of the public, wish to present non-technical testimony about the proposed amendments, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us to notify us that you intend to present non-technical testimony and include any exhibits being prepared. Because this hearing is being transcribed, please remember that only one person may speak at any one time. Please direct your testimony and answers to questions to the board members. Any person who testifies is subject to examination on the subject matter of his or her testimony and on matters affecting his or her credibility. Petitioner has the option of presenting its witnesses as a panel for purposes of cross-examination. Cross-examination by the other party will be conducted at the conclusion of its presentation, followed by cross-examination by the board members and the hearing officer, followed by cross-examination by the public. Please remember to direct all testimony and answers to questions to the board itself, even if someone other than a board member has asked the witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion, and if time permits, rebuttal testimony may be given at the conclusion of the testimony in the same order as direct testimony. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as the direct testimony. We will now proceed if there's no questions about the process. Okay, we will now proceed. So Ms. Jones, are there any exhibits that have been submitted that we need to introduce as evidence?
Yes, Madam Hearing Officer. I have as exhibits, to enter into evidence, the petition for these proposed amendments with exhibits 1, 2A, 2B, 2C, 2D, and 3. Also, NMED's notice of intent to present technical testimony and related exhibits 1 through 20. And then NMED's amended exhibit list attached to the notice of errata to the notice of intent to present testimony. And those exhibits are exhibit 1 through 21.
Okay, thank you, Ms. Jones. Are there any questions from the board members or any objections to including these exhibits into the record? Okay, seeing no objections, the exhibits as stated by Ms. Jones are now admitted into the record. If there are no preliminary matters, we will move to testimony by the petitioner. We will begin with technical testimony by the petitioner. Would the Environment Department wish to make a brief opening statement?
I would. Thank you, Hearing Officer Garcia, member. Good morning, the board and Chair Selena. Today, the Environment Department would like to present this rulemaking matter titled EIB 23-59. My name is Lisa Ty, and I'm the Assistant General Counsel representing the Radiation Control Bureau. Now I'm wondering if you heard all that.
Yes.
You'll hear from Michael Ortiz, Radiation Protection Program Manager for the Bureau. Mr. Ortiz pre-filed his direct technical testimony. Mr. Ortiz will testify about how New Mexico is an agreement state with the U.S. Nuclear Regulatory Commission and is required to ensure that state regulations are compatible with NRC regulations. The proposed rules in this matter are in front of us. The Bureau has prepared PowerPoint slides to assist in the presentation of live testimony at the hearing. On behalf of the Bureau, we ask that Mr. Ortiz be able to use these slides as part of his live testimony after initial direct examination by me.
Anyone have any questions or discussion about that? Okay, that will be allowed.
Thank you. May we please have the slides uploaded?
Yes, stand by.
And while Ms. Jones is uploading the slides, may I ask a question of clarification? This, now that the exhibits have been admitted to the record, I need Mr. Ortiz to also, do they need to be admitted to Mr. Ortiz?
No, that'll be adequate. We've got them in the record now.
Thank you.
So, okay, as you can see, I've got them before. They're just taking a little time to load. Yeah, I see them, just, you guys can't see them.
In the meantime, we could go ahead and swear in Michael Ortiz and Santiago Rodriguez.
Two witnesses.
To hear.
Ortiz.
Yes, paragraph so Garcia is correct. We had added Mr. Rodriguez as an additional witness if had any questions for him after hearing Mr. Ortiz, but we haven't prepared any.
Okay, so right now it's Michael Ortiz needs to be sworn in, so we can go ahead and do that.
Mr. Ortiz, if you would raise your hand, you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, nothing but the truth.
I do.
Thank you.
All right, let me send something to you. There. Okay,
Mr. Ortiz, please state your name for the record.
Michael Ortiz.
Where are you currently?
The New Mexico Environment Department's Radiation Control Bureau,
How long have you been employed by the department?
20 years, from December 27, 2003 to present.
What positions have you held with the department?
Environmental scientist, acting program manager for the radiation protection program, bureau chief of the Radiation Control Bureau, 4 years, 4 months, and currently program manager since November of 2016 to present.
How long have you been the program manager?
6.5 years.
Briefly, what are your duties as program manager?
I oversee the program, which consists of radioactive materials licensing, inspections, incidents and allegations, investigations. The same for the radiation machine X-ray programs, and the current contract that we have with the FDA to inspect market facilities on private lands within the state of New Mexico, following the federal guidelines in the NTSA 1992 Act.
Would you like to continue your testimony with the assistance of the slides, starting on slide 3?
Yes.
Please describe the matter that is here before the board today. I'm sorry, let me restate that. Are we here on a petition to amend rules?
Yes, we are.
Could you please explain what has been entered into the record as Exhibit 1 and Exhibit 2?
So the entire set of rules that contain proposed rules changes are marked and attached to the notice of intent. And that's EIB 23-59 Exhibit 1. Attached to the notice of intent as EIB 23-59 Exhibit 2 are the 90 pages of rules that actually contain the proposed changes.
Thank you. And could you, yes, please continue.
This current slide, the introduction, presentation will help explain the proposed changes to the radiation protection regulations in 20.3.4, 20.3.5, 20.3.12, and 20.3.15, collectively known as 20.3 Mexico Administrative Code. The Radiation Control Bureau requests the board to adopt.
What is the purpose of the proposed rule changes here?
The purpose of most of the proposed rule changes in 20.3 Mexico Administrative Code is to align with Mexico's state regulations with the United States Nuclear Regulatory Commission regulations. The remaining proposed rules changes in 20.3 are to address a health and safety concern and to ensure proper training of all employees working in licensed and registered locations that generate radiation.
Thank you, Mr. Ortiz. Is New Mexico an agreement state with the NRC?
Yes, it is. The state of New Mexico administers the radiation protection program through an agreement between the Nuclear Regulatory Commission, referred to here on as NRC, and the state title agreement between the United States Atomic Energy Commission and the state of New Mexico for discontinuing certain commission regulatory authority and responsibilities within the state pursuant to 274 of the Atomic Energy Act of 1954 and amended and executed on April 3rd, 1974 as further known as the agreement, and that is EIB 2359 Exhibit 5. The agreement provides the discontinuance of the regulatory authority of the NRC and acceptance of that authority by the Environmental Improvement Board and the Environmental Protection Division of the Department of Mexico Environment. C, New Mexico Statutory Authority, 1978, Section 74-3-15. For the duration of the agreement, the EIB shall have the authority to regulate the radioactive materials covered by the agreement for the protection of the public health and safety and the environment from radiation hazards. As an agreement states under 42 United States Code 2021, Section 74-3-15 of New Mexico state regulations must be compatible with the NRC's regulations and under the same 42 United States Code 2021 D2. An agreement state radiation control program is adequate to protect public health and safety if the administration of the program provides a reasonable assurance of the protection of the public health and safety in regulating the handling, use, and storage of agreement materials.
Thank you. Is updating proposed rules one of your job duties?
Yes.
Could you please explain the state's rulemaking obligations?
Yeah, the department, Mexico Environment Department, is required to maintain, develop, and enforce rules for the radiation control as provided in the Radiation Protection Act under Mexico Statutory Authority, 1978, Section 74-1-7, A5, 2000. This includes developing state radiation protection regulations in 20.3 New Mexico Administrative Code that align with their federal regulatory counterparts as required by the agreement between New Mexico and the Bureau.
Thank you. Could you please describe the board's authority to adopt and promulgate rules?
Yes, the Environmental Improvement Board has the authority to adopt the proposed rule changes, and Environmental Improvement Board must consider the advice of and consent of the Radiation Technical Advisory Council, hereafter known as RTAC. And RTAC met on September 20th, 2023 to consider adoption of the proposed changes to 20.3 Mexico Administrative Code. At the September 20th, 2023 RTAC meeting, the RTAC voted unanimously to approve the proposed rule changes. That is EIB 2359 Exhibit 6. The RTAC meeting was conducted pursuant to the Radiation Protection Act, New Mexico Statutory Authority 1978, and the Open Meetings Act, New Mexico Statutory Authority 1978, and was held in person and via WebEx. That's EIB 2359 Exhibit 7. Notice of the September 20th, 2023 RTAC meeting was posted online at the department's, New Mexico Environment Department's events calendar and posted on the Radiation Control Bureau's webpage and provided to the Radiation Control Bureau licensees who would be affected by the proposed rule changes. That is EIB 23-59 Exhibit 7.
Thank you. Could you please describe the actions the department took to meet public notice requirements in statute and rules?
Yes. The department met all public notice requirements. According to the public notice requirements in New Mexico Statutory Authority, 1978, Section 14-42E 2017, and New Mexico Statutory Authority, 1978, Section 14-4-5.2 2017, and I'll continue as EMSA, but it's New Mexico Statutory Authority, 1978, Section 14-4-5.3 2017, 20.1.1.7 again of the New Mexico Administrative Code, and 20.1.1.301 Mexico Administrative Code, and 1.24.15.9 of the New Mexico Administrative Code. Radiation Control Bureau prepared, published, posted, and distributed the New Mexico Environmental Improvement Board notices of scheduled public hearings to consider proposed amendments to 20.3 Mexico Administrative Code of the Radiation Protection Regulations under EIB 2359 in both English and Spanish. It's been known as public notice under EIB 23-59 Exhibit 8. The department described in the public notice all the statutes required and the rule required information about the rulemaking matter and rulemaking process, and that is under EIB 2359 Exhibit 8, thus complying with the Mexico Statutory Authority 1978, which is 14 the same ones that I mentioned before. So I'll end there.
What other actions did the department take to meet public notice requirements?
For public participation, the public notice contained details about how to attend environmental board hearing in person or via WebEx, and listed 3 ways to provide public comments. The first via the smart comment link, the second via emails to the board administrator's email address, the third via physical delivery or mailing addresses to the board administrative physical addresses, that is EIB 23-59 exhibits 9 and 16 and 17. The public notice also included the board administrator's telephone number in case the public had questions. As of February 27, 2024, no public comments were received. And that is under EIB 23-59 exhibit 21.
Please continue with slide 9 in explaining the additional public notice requirements that the department met.
Okay. Pursuant to 20.1.1.301 Mexico Administrative Code, the department published a public notice in both English and Spanish in the Albuquerque Journal on December 19, 2023, and that's EIB exhibit 23-59, exhibit 10. The department also complied with the Mexico PEMSA 1978 section 14-4-5-2A 2017 of the State Records Act by publishing the public notice in the soonest edition of the New Mexico Register, volume 35, issue 1, after the hearing date was set, and that was EIB 2359, exhibit 11.
Thank you. Could you please describe additional public notice and outreach actions as described on slides 10, 11, and 12?
Yes, the department conducted additional outreach by sending the public notice directly to the Radiation Control Bureau licensees and to the Radiation Technical Advisory Committee. The department also complied with the EMSA 1978 of the Small Business Regulatory Relief Act by providing public notice to the Small Business Regulatory Advisory via email on January 31st, 2024, and that is EIB exhibit 2359, exhibit 12. Continuing on, pursuant to the New Mexico Statutory Authority, section 14-4-5.2, and EMSA 1978, section 14-4-5.3, 2017, and 20.1.1.7M, New Mexico Administrative Code, the department provided public notice to the public by 1, posting in the department's website, that's EIB 2359 exhibit 13, posting in New Mexico Sunshine Portal, that's EIB 2359 exhibit 14, making it available at the department's district, field, and regional offices, that's in EIB 2359 exhibit 15, sending it by email to persons who have made a written request for the notice of announcements addressing the subject matter of the rulemaking proceedings and who provided an email address to the board administrator, that is EIB 2359 exhibit 16, sending it by email to the person who participated in the rulemaking by filing an entry of appearance and providing an email address to the board administrator, that is EIB 2359 exhibit 16, and sending the written notice to persons who provided a postal address, that is EIB 2359, Exhibit 17, and providing it to the New Mexico Legislative Council for distribution, the appropriate interim and standing legislative committees. That is EIB 2359, Exhibit 18. And in furtherance of the public outreach, the department developed public involvement plan, and posted it on the Radiation Control Bureau's website. And that is EIB 23-59, Exhibit 9.
Thank you. Moving your attention to slide 13, could you please describe how the NRC has some requirements for the particular regulations that the RCB proposes?
Yes. Although the NRC has discontinued its authority over New Mexico, the NRC maintains oversight authority to ensure that each agreement state, there are 42 agreement states, maintains program elements that are adequate to protect public health and safety and that are compatible with the Nuclear Regulatory Commission's requirements. The NRC regulations contain compatibility categories for agreement states to adhere to when promulgating rules, and there are compatibility requirements with the NRC's regulations. The proposed rules changes in this matter comply with the NRC's compatibility categories and are compatible with the NRC regulations. To maintain agreement state status, the Radiation Control Bureau respectfully requests that the board adopt and promulgate the proposed rule changes in their entirety.
Thank you. Moving to slide 14. Are there potential consequences for not moving forward with the proposed rule changes?
Yes, the consequences of not approving proposed amendments to 20.3 New Mexico Administrative Code. In the event the NRC deems the state's regulations to be incompatible with the NRC regulations, the NRC could sanction the New Mexico Department's radiation control program.
Thank you, Mayor Officer Garcia. This concludes our direct examination of Mr. Ortiz.
Thank you, Mr. Ortiz. Ms. Chai?
Thank you. Board.
Oh, my microphone wasn't on. Thank you, Mr. Ortiz. And Ms. Chai. Does Mr. Maxwell have any questions for the witnesses?
Madam Hearing Officer, I have no questions. Thank you.
Thank you, sir. Do any of the board members have any questions for the witness?
Madam Hearing Officer, I have just a couple.
Okay, Member Ely, go right ahead.
Mr. Ortiz, the rule that went before the RTAC in December is what it's exactly as we are considering it today. Is that correct?
That should be the same case, yes. We would be presenting them for 20.3.4.404 and 20.3.4.455 and 20.3.5.15 and 20.3.12.13 and 20.3.15.1519 New Mexico Administrative Codes.
Thank you. I just have seen a couple different, I've received a few different or probably the same version in my inbox. I just want to make sure that they were all the same. I do have just a couple things to point out on 20.3.5.15. I think there's a typo in A3. Looks like the phrase "as much" was repeated twice.
A3.
Yeah.
So you're referring to the complete A3?
Yeah, let me find the page.
So basically, it says fume badges must be replaced, and then it removes the language up to certified, adds the word personnel, removes the word from dosimeters to 3 months, and then at least monthly and all, and that's the language from the NRC, at least monthly and all other personal dosimeters that requires replacement must be replaced at least quarterly. All personnel dosimeters that must be evaluated must be, is that the one you're talking about?
No, I'm sorry, Mr. Ortiz. Let me find it. I misspoke. It's 20.3.5.15, A3.
Yeah,
on
that's
page
the one I
8.
just read.
Oh, okay. Will you look at 3. It says all personnel dosimeters must be evaluated at least quarterly. I assume that you'll pick that up on the cleanup. My version of the underline states it twice.
Oh, okay, yeah, the one I don't have this one.
It does not.
May I interject?
Yes, Ms. Chung.
I would admit that it's clunky, and I'm not sure if the procedure is to.
Oh, must be evaluated. That must be evaluated at least twice. Yeah, you're right. Got it. Thank you. And then in the next paragraph, or the paragraph D, it's you're talking about dosimeters, and I know what a dosimeter is. It registers radiation to assure you don't get too
Right,
much.
so removing those, that language.
Yeah, it's a chamber.
Excuse me, please, please speak one at a
Yeah.
time. Thank you.
Yeah, so I know what a dosimeter is. I don't know what a chamber is. You cross out dosimeter and you put in chamber.
That is directly from the NRC's language.
Uh-huh.
And that's their new term. Instead of using dosimeters, they've used chamber. And in this case, it's referring to a chamber, which is kind of a dosimeter that measures radiation, but it's their term, and that's why we put it in.
Okay, so some places in the paragraph we use dosimeter and some places we use chamber, but it's essentially kind of the same thing.
Yeah. Essentially the same thing, but now there's new things called electronic dosimeters. You actually just hook up to the computer and read.
And then I want to just back out a little bit. Does RCB have jurisdiction for these rules throughout the state of New Mexico, except potentially Indian lands or?
We have no authority on tribal lands or exclusively federal jurisdiction. The NRC deals with that, and tribal lands have their own.
Okay, so this wouldn't affect like the Los Alamos National Lab.
They have no jurisdiction, only DOE operates that.
And then I think I understand the sources that would be affected by each of these different parts, except for 4. What types of sources would come under part 4?
Under part 4, basically, well, I can explain it better by giving you the licensees. The types of licensees that are affected that have to use dosimeters are all that have radiation above certain limits. And that is 10% of the annual public dose or 10% of the occupational dose. If you're an occupational worker, you're allowed to have up to 500 millirem, which is 10% of the annual dose, which is a lot larger number. And public dose, it is 100 millirem in 1 year or 2 millirem in 1 hour. But these are part 4 mainly to protect the public and the occupational worker. And so they're based on percentages. So if you do not exceed, and you can prove it, if you not exceed 10% of the annual limit for occupational dose, you don't have to have a procedure based on our part 4 regulations and based on the equivalent intensity of our part 20.
And does it apply to all occupational settings?
Yes.
Within your jurisdiction?
If you're dealing with ionizing radiation.
Thank you, that's all.
Thank you, Member Ely. Any other board members have any questions? Yes, Member Trujillo.
Thank you. It was just a follow-up question. I didn't see if chamber was added to the definition ones.
I can see the definition.
that in there or their plans?
No, it is not. And the word chamber is basically taken from the NRC CFR part, wanting the regulations to be compatible with them. Actually, it's under CFR 3447 and CFR 3843. And so what they give us is what's called a radiation amendment technical system. They give us a spreadsheet, and in their spreadsheet, they're called RATs. So in their spreadsheet, they will provide the language that we have to change. So if they provided a definition for chamber, we would have adapted it. But they just put the word in chamber. So put the center in this case and put it in chamber. And that's what we follow. We follow their, again, they're called RATs, but they're radiation amendment technical system. And all of the states have them. We have been doing these almost annually since 1996. That's even before my time. And generally, it's almost annually that we have to do it.
Okay, I understand that. If a New Mexico entity or citizen was going to pick up this regulation and read it and saw chamber in there, what would be your recommendation to them to understand what that term meant and to make sure that they were able to follow the regulation and meet it, but with the understanding of.
It would be a device that could measure radiation out in the field. And it could be one that is, they took out the word dosimeter, but that's really the word that we're used to. That is a badge. I have one in here. Like this, and it measures radiation, but only measures external radiation. And so that badge is sent in. For us, it's monthly. We get readings from different sites to see how much radiation you receive. But nowadays, they have chambers and they have electronic badges, which are much different. So if you had a chamber, you would actually have something to look at the end of your visit, see how much you had at that particular time of radiation. But you have to make sure that the chamber is zero before you go into the place, because the sun will change the readings on the chamber. If they're electronic badges, they're basically a system that records the radiation that you receive externally only, and is limited to mainly photons and high energy betas. It will not measure alpha radiation. And it can be put on your computer, it goes to the company's site. Miriam is one of the sites, and Landau is another, and they can read that for you and give you.
Thank you, and I appreciate you explaining what a chamber is and a dosimeter as well. I would one of your regulated entities be able to understand that a chamber is also a dosimeter? Would this language translate relatively easy to somebody picking up the regulation and understanding what their requirements are?
Yes, those that use dosimeters or chambers or electronic badges that are in the field understand what they do. In some cases, there are some, for example, our licensees from industrial radiography, they deal with hundreds of curies, written 100. So they have 3 systems. They have external dosimeter put on a collar. They have a pencil dosimeter, which is like a chamber that they carry that can read real time. And then they have a dosimeter that they have to carry with them because there's so much radiation in the area whenever they deploy the source out. They have to set up a 2 millimeter line to work. They have sure they need. So there are certain circumstances, very small, that are required, really.
Thank you, and again, I appreciate the additional information there. Really what I was focusing on was making sure that it was very clear in the regulation that this is what it is, and that this change and there's a definition associated with it. So there's no actual question there, but that's ultimately the focus of my life. I don't have any questions.
Thank you. Vice Chair.
Thank you, Vice Chair Trujillo. Any other questions from the board? Okay. Any other testimony from the witness, Ms. Chai?
Ask a question on redirect.
Yes, you may.
Would the regulated entities be able to refer to NRC regulations and policies to look for how the NRC is defining the word changing?
They can,
Thank you.
and they probably will. They often find the book. We have kind of equivalent regulations that are in code. So our 20.3.4 administrative code is almost equivalent to 10 CFR 21. 10 CFR 20.
Thank you, Mr. Ortiz.
Thank you very much. Okay, if that concludes that testimony, I will now move to Mr. Maxwell. Do you wish to make an opening statement, Mr. Maxwell?
Madam Hearing Officer, I have nothing for the record today. Thank you.
Thank you, Mr. Maxwell. Is there, I'd also like to ask if there's any members of the audience or any members of the public that have any questions for the witness today. No, okay. At this time, we can move on to any non-technical testimony or take written statements from members of the public. Is there any members of the public that wish to give any non-technical testimony? Ms. Jones, do you see anyone on the platform that has raised their hand?
Madam Hearing Officer, I do not.
Okay, thank you. Is there anyone who wishes to have any cross-examination for any of the witnesses? No, okay. All right, then at this point, does NMED have any rebuttal testimony they would like to offer?
NMED has no.
Okay, thank you, Ms. Chai. Then we can move on to any closing statements. Does NMED wish to make any closing statements at this time?
We do not. Thank you. We all.
Okay, thank you, Ms. Chai, and thank you, Mr. Ortiz. All right, then I would like to thank the board and everyone present for participating today, and thank the witnesses and Ms. Chai. We had a quorum of board members attending this hearing. Let's see, so at this time, the record is closed. And let the record show that this hearing was adjourned at, looks like 10:44. If there's any reason that someone wishes to keep the record open, please let me know if there's anyone who wishes to keep the record open. Okay. So the record was closed at 9:44 then. And, oh, sorry, 10:44. Sorry, 10:44. All right, then I will adjourn the hearing at this time at 10:44. Thank you. I'll turn it over to Madam Chair.
Thank you, Madam Hearing Officer Garcia. At this point, after the rules hearing is concluded, I'd like to look to the fellow board members to discuss whether you would like to deliberate and make a decision today. And if so, just looking around, want to hear some feedback. I see some head nodding, yes, okay. All right, the board, therefore the board will immediately deliberate to make a decision on the proposed amendments. If while deliberating, the board determines that additional testimony or documentary evidence is necessary for a proper decision on the proposed amendments, the board may, consistent with due process requirements, reopen the hearing for such additional evidence only. Let's see. And let's see. All right. So as we go into deliberation, just I know we have these amendments. If it's there, I know there were some questions earlier, but it seemed pretty straightforward. And just hearing seeing some nods, but I want to make sure that we can have a full discussion on the amendments, proposed amendments or any process. So if anybody has any questions at this point, I'd love to hear those.
I'm comfortable with the rules as drafted. I noticed there is no definition of dosimeter either in there, so I'm sure that people will be referring to the NRC rules for clarification on this. I believe it's an essential step to keep us in our agreement with the feds in place, so I'm happy to support these motions.
Thank you for that, Member Avery. Is there any other comments or questions, discussion? Okay, if not, I know we have the proposed rules that have been submitted by NMED, and we have a number of changes throughout the regulation. I know in the past we went line by line on those changes. Legal counsel, do we need to do that on this as well? Just for the record, a lot of them are just, making sure that we're consistent with the federal regulations, or how we, any recommendations?
Thank you, Madam Chair. No, you can adopt them as they're drafted and as they're presented.
Thank you so much. Makes our job a little bit easier and straightforward. With that, so with that guidance from our legal counsel, having reviewed this and having heard the testimony, and again, hearing some clarification questions, I've looked at this myself and see the very thorough job of, the revisions being presented in the exhibits and the background on those revisions and the justification for those revisions. Is there any further discussion or maybe entertain a motion from our board? Yes, Member Hunker?
Yes. Excuse me. I will move that we adopt the proposed rule revisions as submitted by NMED under item number EIB 2359, based on the record before us and the testimony we heard today.
I'll second that.
Thank you, Member Hunker and Member Bitzer, with the motion on the floor to accept the amendments based on the record and the testimony heard today on this item. Do we have any further discussion? We have a motion on the motion. If not, Legal counsel, is that motion comprehensive enough, to make sure that we have the, documentation and on record for any required order information or documentation?
Yes, that's sufficient.
Thank you.
Excuse me, speak up, please. Sure. I just said, yes, that's sufficient.
Thank you, legal counsel. So with that, I'm gonna look to Ms. Jones to do a roll call vote on Member Hunter's motion.
Okay, the motion to adopt the proposed rules, the rule revisions is submitted by NMED. Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
The motion passes.
Thank you so much, Ms. Jones, and thank you to legal counsel and our witnesses here today and NMED here today. With that, the board's decision will be issued in writing and will include its reason for the action taken. Our board administrator shall provide the notice of the board's action to each of the participants in the hearing and to all persons who have made a written request to the board for notification for the action taken. Thank you so much for coming this.
Thank you.
Thank you. And with that, let's see. I think that's it on this matter on agenda item EIB 20-59. Appreciate our court reporter here as well. With that, I know that we had movement of agenda items. So just trying to see a feel before going on to the next one, which is EIB 23-75. Just a public hearing in the matter of proposed amendments to 20.3.16 NMAC. Are we ready to go? Yes, member.
I would propose we take a short break before we want to change that.
Okay, board members, 5-10 minutes, let's do 10 minutes. All right, which, yes, I failed to do this. Let's come back at 11. Thank you. Good morning again. We will be reconvening here in a moment. We're just waiting for our legal counsel to come back into the room. Just wanted to let folks know who are on. Record. It is 11:07. And we are on our next agenda item, which is EIB 23-75, public hearing in the matter of proposed amendments to 20.3.16 NMAC. And Ms. Chai, legal counsel for NMED, and our hearing officer is Member Honker. So at this moment of time, I will turn the baton over to Member Honker as our hearing officer. Thank you.
Okay, thank you, Chair Sweeney. Carol, you ready to go?
Yes, thank you.
Okay. The hearing will please come to order. Today is Thursday, February 29th, 2024. The time is now 11:08 a.m. My name is William Honker. I have been designated by the board to serve as hearing officer, and I will be advised by the board's counsel from the Office of the Attorney General, Emily Bone. And we have a roll call of the board. Scales.
Yes. Member Bitzer, are you present?
Yes, I am.
Member Ely?
Present.
Member Garcia,
Here.
Member Trujillo. Present. And Member Sweeney. Present. Hearing Officer Holmer.
Doesn't,
You have a quorum.
okay, thank you, Ms. Jones. This is a hearing in EIB 23-75 to consider the proposed amendments to 20.3.16 NMAC. Although this hearing is being conducted in person, Rule 20.1.1.306 NMAC allows for participation by video conference, telephone, or other similar device given all participants are able to hear. If there are technical difficulties at any point during the hearing, please bring them to my attention and efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environment Department Radiation Protection Bureau. Nicholas R. Maxwell filed a notice of appearance and is a party to this proceeding, but did not file a notice of intent to present technical testimony. Nicholas R. Maxwell will not offer any technical witnesses. There will be designated time for any member of the general public to present non-technical testimony. The hearing will be conducted in accordance with the Open Meetings Act, State Rules Act, the Environmental Improvement Act, and with this board's rulemaking procedures. The hearing is being reported by Cheryl Aragon from Albuquerque Court Reporting Services. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing. Copies of the proposed amendments have been available on the department's website and at the department's office, as well as to interested parties upon request. The hearing will be conducted in a fair and impartial manner to ensure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask that all persons at this hearing please silence their cell phones. If appearing virtually, be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. First, board staff will present pre-filed exhibits. Exhibits admitted into evidence are available for review by the public. Second, all testimony will be taken under oath. Third, as hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Number 4, any person offering an exhibit shall provide an original to the board administrator and a copy to each of the board members and to its legal counsel, and shall also provide additional copies for persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. 5, any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Number 6, petitioner will present its direct testimony on the proposed amendments, and petitioner's witnesses will stand for cross-examination by Nicholas R. Maxwell, the board, and any other person in attendance. Number 7, Nicholas R. Maxwell will then have an opportunity to present an opening statement. Number 8, if any other persons, including members of the public, wish to present non-technical testimony about the proposed amendments, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us. to notify us that you intend to present non-technical testimony and include any exhibits being offered. Number 9, because this hearing is being transcribed, please remember that only one person may speak at any one time. Please direct your testimony and answers to questions to the board members. Number 10, any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. The petitioner has the option of presenting its witnesses as a panel for purposes of cross-examination. Cross-examination by the other party will be conducted at the conclusion of each presentation, followed by cross-examination by the board members and hearing officer, followed by cross-examination by the public. Please remember to direct all testimony and answers to the questions to the board itself, even if someone other than a board member has asked the witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion and if time permits, rebuttal testimony may be given at the conclusion of the public testimony in the same order as the direct testimony. Number 12, any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as the direct testimony. We will now proceed. I do want to mention that we have received a request from Mr. Maxwell for a continuance of the hearing, but based on the discussion earlier today, Mr. Maxwell has withdrawn that due to the rescheduling of the order of the hearing. I will also consider whether or not to extend or leave the record open at the end of the hearing. In case there's an interest in more time, those arguments can be made then. Okay, we will now proceed. Does the board staff have any exhibits to introduce as evidence?
Yes, sir, Mr. Hearing Officer. I have as exhibits the petition to repeal and replace 20.3.16 NMAC and its exhibits 1 and 2. NMED's notice of intent to present technical testimony with its exhibits 1 through 35, and the amended petition with exhibits A, B, and C. And then the notice of errata to the notice of intent to present technical testimony with its amended exhibit list, exhibits 1 through 24.
And are those all of the exhibits received by the board?
Yes, sir.
Okay. Fine. Ms. Chai?
Hearing Officer Hunter, I believe the exhibits that were filed, the notice of errata, if you add it, I guess, refer back to the NOI that have 35 exhibits, the notice of errata now mentions 37 exhibits. I'm not sure. Someone can potentially do any of that.
Okay, so have we covered all the exhibits that have been submitted in this discussion? Are there any questions from the board members or objections to allowing these exhibits? Exhibits 1 through 37?
Yes, on the notice of errata on the last page after the certificate of service, we have an amended or updated exhibit list that lists exhibits 1 through 37.
Okay. I'll admit exhibits 1 through 37 into the record. If there are no other preliminary matters, we will move on to testimony by the petitioner. We will begin with technical testimony by the petitioner. Does the petitioner wish to make a brief opening statement?
Yes, please. Thank you.
Go ahead.
My name is Lisa Chai, and I'm the Assistant General Counsel representing the Radiation Control Bureau on this matter captioned EIB 23-75. Today, you'll hear from Santiago Rodriguez, RCD Bureau Chief, who is appearing virtually via WebEx. Next, RCD Staff Manager and Program Manager Michael Ortiz will testify, and then Environmental Protection Division Director Michelle Miano will testify. On behalf of the Bureau, we ask that the 3 witnesses who pre-filed their direct technical testimonies be able to use the PowerPoint slides they prepared as part of their live testimony after direct examination introductions by me. Also, since they collectively will testify on the proposed rule changes, we appreciate the board allowing these 3 witnesses to complete their direct testimonies with the use of the slides and then answer the questions of the panel. Division Director for Compliance and Enforcement, Bruce Basil, is also available upon request to be sworn in and answer questions virtually as needed and as part of the panel. The proposed changes to the regulations titled Fees for Licensure of Radioactive Materials in 20.3.16 NMAC will change the fees assessed by the Radiation Protection Program. The new fee structure is very much needed to sustain and support the Radiation Protection Program. These rules were originally promulgated nearly 22 years ago, and updates to these rules are long overdue. I'll let the witnesses expand on this with their knowledge and expertise. And I would, before I begin the direct examination, just ask if the chair also approves of the slides as the witnesses testimony today.
I'll approve that, and I believe we need to swear in the witnesses.
Yes.
If the board reporter will do that.
Yes, if you all will raise your right hands, I believe there's 3 of you. Great. Do you and each of you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth? One at a time, please.
I do.
Thank you.
Petitioner may now present direct testimony on the proposed amendments.
Yes, thank you. And now I would like to ask for the slides to be uploaded onto the screen. Thank you. Could you please turn to slide 2, Ms. Jones?
Yes.
Thank you. Our first witness is Santiago Rodriguez. Mr. Rodriguez, for the record, please state your name.
Santiago Rodriguez.
Where are you currently?
I work for the New Mexico Environment Department Radiation Control Bureau.
How long have you been employed with the department?
So I've been employed with the New Mexico Environment Department Radiation Control Bureau for 17 years.
What positions have you held in the department?
I entered into the Environment Department's Radiation Control Bureau as an environmental scientist and specialist operational. I've held a position of staff manager, acting manager, acting bureau chief, and now my current position as bureau chief of the Radiation Control Bureau.
How long have you held your current position?
I have been in my current position approximately 8 years.
What are your duties as bureau chief?
So my duties include responsibility of technical, budget, administration, and management of several programs, contracts, and federal grants with a total of 18 people that report directly or indirectly to me, and with an operating budget of approximately $1.95 million coming in from various revenue streams.
Is another duty helping to move forward proposed regulations?
Absolutely.
Thank you. Since the exhibits have already been admitted to the record, exhibits 1 through 37, I'd like to turn your attention to the PowerPoint slides that will assist you in presenting your testimony today. Could you please start with slide 3?
Yes. So before I start, I just want to say it is an honor and a pleasure to be here this morning before the distinguished panel, board members, Chair Sweeney, Hearing Officer Honker, and distinguished members of the panel. I want to thank you in advance for your consideration, your time, and attention to this matter. So with that said, I will continue. The Radiation Control Bureau proposes changes to the regulations of 20.3.16 of the New Mexico Administrative Code. So fees for licensure of radioactive materials. The fees for radiation protection program participants are in these regulations, which are originally promulgated in May of 2002. Continuing to manage the radiation protection program with 22-year-old fees is not sustainable at this time. All fees for licensure of radioactive material would increase under the proposed rule changes. Next slide, please.
Mr. Santiago, I would like to direct your attention to slide 5, and please briefly describe the actions that the Radiation Control Bureau takes.
So the Radiation Control Bureau oversees the beneficial uses of ionizing and non-ionizing radiation and helps to protect the worker, the public, and the environment from the potential hazards that radiation can pose. So how do we do this? We do this through different programs within the Bureau, the Radiation Protection Program, the Medical Imaging and Radiation Therapy Program, the State Indoor Radon Outreach Program, the Waste Isolation Pilot Emergency Preparedness Program, and this section meaning the Radiation Protection Program also administers natural occurring radioactive material, which is primarily found in oil and gas operations. How do we do this? We do this through licensing, inspection, and enforcement. So the proposed rule changes in this matter pertain solely to the Radiation Protection Program as defined above.
Thank you. Please describe the agreement status for the record in this matter. On slide 6.
So the state of New Mexico administers the Radiation Protection Program through an agreement between the U.S. Nuclear Regulatory Commission and the state. So that is titled the agreement between the United States Atomic Energy Commission and the state of New Mexico. And this allows for the discontinuance of certain commission regulatory authority and responsibilities within the state pursuant to Section 274 of the Atomic Energy Act of 1954, as amended and executed on April 3rd of 1974, titled Agreement. This can be found under EIB 23-75, Exhibit 5. While the NRC has discontinued its direct authority over New Mexico radiation licensure, the NRC maintains oversight authority to ensure that each state maintains program elements that are adequate to protect public health and safety and are compatible with NRC requirements. As an agreement state under federal regulations and state law, the NRC must be assured that the state's radiation control program is deemed adequate to protect public health and safety through effective program administration, including regulating the handling, use, and storage of agreement material.
Thank you. Turning to slide 7. Would the proposed rules in this matter, EIB 23-75, be compatible with the NRC's regulations and expectations under the agreement just described?
So the fee structures proposed rule changes align with the NRC's fiscal year 2021 fees. The NRC supports the fee structure that would be implemented with the proposed rule changes, and this can be found under EIB 23-75 Exhibit 36, which is a letter of support from NRC to the board chair.
Thank you. On slide 8, for this matter's record, could you please describe the board's ability to adopt and promulgate regulations?
Yes, thank you. So the EIB has the authority to adopt the proposed rule changes, and the EIB must consider the advice and consent of the Radiation Technical Advisory Council, known as RTAC. See NMSA 1978, Section 74-1-8A 5, 1953, amended 2020, NMSA 1978, Section 74-1-9, 1953, amended 1985, and NMSA 1978, Section 74-3-5A, 1955, amended 2000. So the RTAC met on December 19th of 2023 to consider adoption of the proposed changes to 20.3.16 of NMAC. At the December 19th, 2023 RTAC meeting, the RTAC voted unanimously to approve the proposed rule changes. EIB 23, this is found as EIB 23-75 Exhibit 6. At the RTAC meeting was conducted pursuant to the Radiation Protection Act of NMSA 1978, Section 74-3-1-16, and the Open Meetings Act, NMSA 1978, Sections 10-5-1 to 10-4, and held in person and via WebEx, found as EIB 23-75 Exhibit 7. Notice of the December 19th, 2023 RTAC meeting was posted online on NMED's events calendar, posted on NMED's and RCB's webpage, and provided to RCB licensees who would be affected by the proposed rule changes. This can also be found as EIB 23-75 Exhibit 7.
Thank you, Mr. Rodriguez. I'd like to ask Ms. Jones to turn back to slide 4 so Mr. Rodriguez can address the version of the proposed rules and whether that version was the same version approved by RTAC on December 19th.
So the proposed rule changes that RCB requests the board to adopt are marked and attached to the NOI as EIB 23-75 Exhibit 1. An explanatory matrix showing the crosswalk of the proposed rule changes is attached to the NOI as EIB 23-75 Exhibit 2. To initiate this rulemaking on November 9, 2023, RCB filed a petition to repeal and replace 20.3.16 NMAC of the Radiation Protection Regulations and request for hearing, attaching first filed versions of the proposed rule changes and statement of reasons. On December 15, 2023, at the EIB meeting to schedule the hearing, Council informed the board that an updated version of the proposed rules that fix typographical errors would be filed. On December 19, 2023, RCB presented to the Radiation Technical Advisory Council, RTAC, the amended version of the proposed rules that RCB filed 2 days later with the board. This brief procedural history summary is to explain that the proposed rules that were attached to the NOI as EIB-23-75 Exhibit 1 were approved by the RTAC on December 19, 2023, and 2, filed and accepted into the record on December 21st, 2023 with the amended petition.
Thank you. I'd like to ask that we turn to slide 9 and Abby would describe the actions the department took to meet public notice requirements in statute rule.
Thank you. So the public notice requirements in NMSA 1978, section 14-4-2E of 2017, NMSA 1978, section 14-4-5.2 of 2017, NMSA 1978, section 14-4-5.3 of 2017, 20.1.1.7N NMAC, 20.1.1.301 NMAC, and 1.24.15.9 NMAC, RCB prepared, published, posted, and distributed the New Mexico Environment Improvement Board notice of scheduled public hearing to consider proposed amendments to 20.3.16 NMAC of the Radiation Protection Regulations, EIB 23-75 in both English and Spanish, known as public notice. This is found as attached as EIB 23-75 Exhibit 8. The department also described in the public notice all the statute required and rule required information about the rulemaking matter and rulemaking process. The EIB 23-75 Exhibit 8, thus complying with NMSA 1978 Section 14-4-2E 2017, NMSA 1978 Section 14-4-5.2 2017, NMSA 1978 Section 14-4-5.3 2017, 20.1.17N NMAC, 20.1.1.301 NMAC, and 1.24.15.9 of NMAC.
Thank you. I'd like to direct your attention to slide 10. Could you please continue to your description of public notice?
Yes, in a continuance of public participation and public notice, the details of how to attend the EIB hearing in person or via WebEx are listed. 3 ways to provide public comment: via smart comment link, via email to the board administrator's email address, via physical delivery or mailing address on the board administrator's physical address. EIB 23-75 Exhibit 9 is where this can be located. The public notice also included the board administrator's telephone number in case the public had questions. As of February 27th, 2024, only one smart comment, which was in support of the proposed rule changes, has been received. This is EIB 23-75, Exhibit 37.
Thank you. Please continue to the next slide about public notice requirements being met by the department.
So pursuant to 20.1.1.301 NMAC, the department published the public notice in both English and Spanish in the Albuquerque Journal on December 19, 2023. This is Exhibit 23-75, Exhibit 10. The department also complied with NMSA with NMSA 1978 Section 14-4-5.2A 2017 of the State Records Act by publishing the public notice in the soonest edition of the New Mexico Register, Volume 35, Issue 1, after the hearing date was set. This can also be found at EIB 23-75, Exhibit 11.
What additional outreach did the department conduct?
So the department conducted additional outreach by sending public notice directly to RCB licensees and to the Radiation Technical Advisory Committee or Council. The department also complied with NMSA 1978 Section 14-4A-4 2005 of the Small Business Regulatory Relief Act by providing public notice to the Small Business Regulatory Advisory Commission via email on January 31st, 2024, EIB 23-75, Exhibit 12.
What additional public notice requirements did the department meet?
So pursuant to NMSA 1978, Section 14-4-5.2, NMSA 1978, Section 14-4-5.3, 2017, and 20.1.1.7 NMAC, the department provided the public notice to the public by posting it on the department's website, EIB 23-75 Exhibit 13, posting it on the New Mexico Sunshine Portal, EIB 23-75 Exhibit 14, making it available at the department's district, field, and regional offices, EIB 23-75 Exhibit 15, by sending it by email to persons who made written requests for notice of announcements addressing the subject matter of the rulemaking proceeding and who provided an email address to the board administrator, EIB 23-75 Exhibit 16, by sending it by email to the person who participated in the rulemaking by filing an entry of appearance and providing an email address to the board administrator, EIB 23-75 Exhibit 16, sending written notice to persons who provided a postal address, EIB 23-75 Exhibit 17, and providing to the New Mexico Legislative Council for distribution to appropriate interim and standing legislative committees, EIB 23-75 Exhibit 18.
What other actions did the department take for public outreach?
So we also, in the furtherance of public outreach, the department developed a public involvement plan, PIP, and posted it on RCB's webpage. This is EIB 23-75 Exhibit 19. So the department has met all public notice requirements regarding 23-75 matter.
Did the department also conduct further public engagements?
Yes, they did. So to provide ample opportunities for public engagement on the proposed rule changes that would raise radiation materials license fees if adopted, the department provided 2 additional opportunities for the public to hear presentations and ask questions. NMED posted notices of the public informational meetings on its websites. This is EIB 23-75 Exhibit 20. On December 13th, virtually via WebEx, on December 14th, in person at the Marquez Building in Santa Fe, the Radiation Control Bureau presented informational slides on the proposed changes to 23.3.16 NMAC. This is Exhibit 23-75, Exhibit 21.
Thank you. I'm going to turn your attention to slide 17. And like you described as the bureau chief, your experience of the program's operations in light of the 2002 fees being relied on.
Thank you, Lisa. So the Radiation Control Bureau is still collecting fees that were deemed in 2002 to be adequate to fund the program. The current Radiation Control Bureau fee is, as described in 20.3.16 NMAC, were promulgated in May of 2022 and are insufficient to support the program at today's cost. The cost of doing business, ensuring the protection of New Mexicans and the environment, has steadily increased over time, while RCB's radioactive materials license fees have not increased since 2002. Costs in the United States have risen approximately 41% since 2002, based on calculations made in the U.S. Bureau of Labor Statistics Consumer Price Index Inflation Calculator 2, EIB 23-75 Exhibit 23, showing that $1 million in current U.S. dollars as of December 2023 has the same buying power as $586,152.71 did in May of 2002. When 20.3.16 NMAC was promulgated, so EIB 23-75 Exhibit 25. So in addition, RCB staff base salaries have increased approximately 48% from fiscal year 2004 to fiscal year 2024 for ESSOs and ESSAs respectively. This is EIB 23-75 Exhibit 24, and the benefits are additional, approximately 38% above that. So you can see the cost of doing business has increased while the fees have remained stagnant and are not sufficient to support programmatic our program management responsibilities.
Turning your attention to slide 18, how does the NRC conduct business?
So the proposed changes to 20.3.16 NMAC will align the state's radioactive material license fees with NRC's fiscal year 2021 fees. So EIB 23-75, Exhibit 22 is where this can be located. Congress expects the NRC to charge and collect fees in the amounts that cover most of its operational costs. So this is EIB 23-75, Exhibit 26. The NRC has indicated that it collects fees in the amount equal to approximately 90% of its budgetary needs. This can be found as EIB 2375, Exhibit 27.
Please turn to slide 19 and describe potential consequences of these proposals not moving forward.
So the potential consequences of not approving the proposed changes. So in the event that the NRC deems the program to be inadequate to protect public health and safety and the environment, the NRC could move to terminate the agreement with the state and resume regulatory oversight of the radioactive materials licensees in New Mexico. This would result in higher federal license fees and non-local customer assistance.
Turning to slide 20, please describe what you would like to see.
So adopting the proposed rule changes would provide the budget and the fiscal stability RCB needs to successfully manage the program. With additional predictable recurring revenue, RCB will be better able to regulate the safety of radioactive materials handling at over 200 locations in the state and thus appropriately address human health and safety concerns to protect the environment. The proposed rule changes are much needed to ensure the viability of the radiation protection program.
Please continue on slide 21.
The fee structure in the proposed rules would provide much needed fee revenues for the viability and sustainability of the radiation protection program. It would also provide predictability. The fees in the proposed rules are based on the NRC FY21 fee structure. Adopting the proposed rule changes would bring the Radiation Control Bureau's radiation protection program fees in closer alignment with the federal counterpart.
Thank you, Mr. Rodriguez. This concludes my direct examination of this witness.
Thank you, Ms. Chai.
And Aaron Officer, I would ask to proceed with the direct examination of the next witness in order to have questions addressed to the three witnesses as a panel.
Okay, yes, you can proceed to the next witness, and then the witnesses will be cross-examined as a.
Thank you. Mr. Ortiz, please state your name for the record.
Michael Ortiz.
For the record, please state where you're currently employed.
New Mexico Environment Department Radiation Control Bureau.
How long have you been with the department?
20 years, from 2007, 2003 to present.
What positions have you held in the department?
Environmental scientist, operational and advanced, acting program manager, and bureau chief, and now currently program manager of the radiation protection program.
How long have you held your current position?
6.5 years.
Briefly, what are your duties as program
I oversee inspection, enforcement, radioactive materials administration by the state in agreement with the NRC, and we follow all of the NRC's requirements to meet the audit conditions that they impose on us.
As one of your duties moving forward, proposed regulations?
Yes.
I'd like to turn your attention to the slides for your use in testifying today. Please turn to slide 22 and please tell us about the radiation protection program.
Sure. Some of the multiple requirements for operating the radiation protection program described as program as a U.S. Nuclear Regulatory Commission, referred to as NRC agreement state, is EIB 23-75, Exhibit 5, and it includes radioactive materials licensing, inspections, inspection equipment purchases, calibration, hiring, training, and retraining staff, updating regulations and regulatory requirements to maintain compatibility with the NRC. These requirements are expensive actions that involve many additional operational costs, such as technology, rent, travel, etc. The program requires adequate funding to adequately protect Mexicans and our environment from the potentially harmful effects of radiation used and or disposed of by persons handling radioactive material under the Radiation Protection Act, EMSA 1978, Section 74-3-1 at CEPO and related regulations.
Thank you. Turning to slide 23, please describe the format of the proposed rules in this matter.
Proposed changes repeal and replace rather than amend 3.16 Mexico Administrative Code per state representatives and archives rules. Because they're so old, that's why they require us to repeal them. The proposed rule changes are in 20.3.16.1, issuing agency. There's really no change there. Under 20.3.16.2, again, scope rules apply to license holding fees and activities pursuant to Chapter 10, Title 20 of the Mexico Administrative Code. I won't continue input the 20.3.16. I'll just give you the part point or sections. Point 3, statutory authority. There's no change. Point 4, duration, no change. Point 5, effective date is going to be a promulgation date. Point 6 is the objective. Updates reflects proposed fee structure. Point 7 are definitions. The added, deleted, and updated definitions. Point 8, interpretations, no change. Point 9, consumer price index fee adjustment. The new fee structure applies the consumer price index after fiscal year 2026, so that the fees keep up with the market costs. Point 10 are the annual fee schedule, license application fees, amendment application fees, and annual fees. Require the department to annually publish a fee schedule for each established fee in the new fee structure. See proposed fee structure.
Before you proceed and leave slide 23, I just would like to address a couple of the sections that you covered. Point 5, effective date. You mentioned it's the promulgation date. I believe the rules that are attached as Exhibit 1 may say May 1st. And would it be possible that the state records would insert the effective date based on the promulgation date, which is based on the Mexico Register publication dates?
Yes.
Thank you. And before we proceed, also on section 10, it does say see proposed fee structure change. Is that something that you have a final draft of yet, or are we waiting for the possible adoption of rules before finalizing a draft?
Waiting for the final adoption.
Thank you. Let's turn to slide 24.
Continue on the 20.3.16.11 and category materials licenses, application fees, and annual fees. So under 20.3.16.11A, and from then on, I'll just go with the letters to describe and that of the new fees. G is a special nuclear material, which specific materials, plutonium 239, uranium 233, and uranium 235, which are fissionable isotopes, but we can't license anything that is above certain quantities. The NRC licenses physical quantities. C is source material. Source material is uranium and all its daughters, and thorium. As they occur naturally in nature, they're referred to as norm as sometimes. B, our byproduct material, that's everything else that is not source material or special nuclear material, including medical isotopes. E is waste disposal and processing. That category we've never licensed before, so E, there's no licenses since the department, the Radiation Control Bureau has been in existence. F is well logging. Those are people that serve the oil and gas industry mainly. G is the nuclear facility or laundries. There's only one that we licensed in the state. H are medical licensees, and those will be licensees that have nuclear medicine facilities for diagnostic and therapy. I is civil defense. Again, there we've never licensed any civil defense operations in the history of the Radiation Control Bureau. J is reciprocal recognition of licenses. That is basically doesn't have an annual fee. It has an application fee, and basically they are coming in from other states, having a specific license, usually from that other state. And if their license allows them to do temporary job sites and perform duties in our state, we will issue them what is called a general license, but they have to have a specific license to get it. But then we enforce it under our regs 20.3 and that. So even though their rules, their license may have certain things in it, we'll enforce our rules if they come in our state. And they're only allowed to work up to 180 days per calendar year. And they have to reapply every calendar year. The K category is a new category, and it's basically to catch any new licenses that come up. And there's all kinds of new nuclear medicine procedures that are coming up for treatment therapy and diagnostics. Continuing on.
Yes, please.
Yeah. Going to 20.3.16.12, next to administrative code. This is our small entity and annual fee updates entities. We had this in our last regulations also, but they've changed because we adapted the NRCs. And basically it provides licensees that are small businesses that are below certain thresholds, dollar amounts in gross revenues per year, or number of employees, to actually pay a lesser fee. There is a 1A fee if they qualify for that, they only pay $4,900, and there's a 1B, and that's another lower category that'll pay $1,000. And so those are the two categories, small businesses that they can take advantage of if they qualify and they certify. Under 20.3.16.13, that is a proration table. That is a one-time proration fee to bring all licensees to the annual fee due date of July 1 of each year, beginning in July 1, 2024, for licensees that were issued prior to July 1, 2024. EIB Exhibit 2375, Exhibit 30 for more details. 20.3.16.14 and that is payments, collections, and costs, update payment schedules and collections. 20.3.16.15 and that is license termination. This establishes a streamlined license termination fee. 20.3.16.16 is the annual revenue amended to develop a schedule and a process to review and present fees and costs established in this part. 20.3.16.17 is reserved, and so is 18. So you can refer to the matrix, EIB 23-75 Exhibit 2 for the review of the amendments of 20.3.16.
Thank you, Mr. Ortiz. You've already described some, a brief description of some of the changes. Would you like to further briefly summarize the proposed changes?
Yes. Here's a brief summary of the new structure fee that would be implemented following promulgation of the proposed rules. The fee structure is implemented in a phased approach over 2 years. So in FY25, they'll be paid less then the full amount will be due in fiscal year 2026. Starting in fiscal year 2027, all fees will be adjusted using the Consumer Price Index. If there is an increase in inflation, fees will be reduced, will not be reduced if there is a reduction in the CPI. As the current regulations currently apply, the annual fees on the effective date of the license or the anniversary date of the licensee. The proposed rule shall prorate annual fees incurred in fiscal year 2024 to bring all licensees to an annual fee date of July 1. Fees for the upcoming fiscal year will be published in advance of July 1. Application fees and amendment fees shall be due with the application or amendment request submitted. The annual fee for existing licensees shall be due on July 1 of each year with a 30-day grace period before late fees are applied. The annual fee for new licenses shall be due within 30 days of the issuance of a new license. An amendment fee in the amount of 25% of the licensee's application fee shall apply to each amendment request submitted by the licensee for review by the department during the terms of the license. A license termination will require payment of a flat fee in the amount of $1,000. The Radiation Control Bureau has eliminated the at full cost that's in the NRC schedule option in lieu of a set fee, where NRC assesses at full cost, RCB is keeping the current fee. This current fee only applies to source material licensees under 20.3.16.B1 and waste disposal and processing under 20.3.16E1B. As I mentioned before, we've never licensed the Bureau anyone in that category. Additionally, differences between the current and the proposed versions of 20.3.16 MF are described in the matrix, and that can be found under EIB 2375, Exhibit 2.
Would the board like for Mr. Ortiz to itemize the proposed rule changes in more detail?
Any of the board members see any further detail on this?
I don't, I will ask questions when the time is appropriate.
Yes, hearing officer, that's the same thing for me. We've got a lot of crosswalks and good to walk through with the.
Could you repeat that, please?
I just said that, I think the crosswalk along with, the presentation, it's been, good to follow, so.
Okay, so we don't need any.
Thank you, Officer. Just so we know members of the board. Mr. Ortiz, would you like to just recite the exhibits that
Yes.
could help provide more
The
detail?
proposed rule changes in 20.3.16 Mexico Administrative Code are attached to the notice of intent as EIB 2375 Exhibit 1. Current rules, as a demonstrated in extreme matrix, show a crosswalk of the proposed rule changes are attached in the notice of intent as Exhibit 23-75 Exhibit 2. A proration table is also provided And it's attached to a notice of EIB 2375, Exhibit 30. An NRC compatibility category summary attached to the notice of intent as Exhibit 23-75, Exhibit 31.
Would you like to conclude with slide 29?
Yes. To help institute radioactive protection programs sustainability, the Radiation Control Bureau requests that the board adopt and promulgate the proposed rules changes in there.
Thank you. This concludes the department's direct examination of Mr. Ortiz's testimony.
Thank you.
May we continue the next witness, Shelley?
Let me just do a time check. You have an estimate of the time that will be needed for the remainder.
Possibly 10 minutes.
Okay. As long as the board members and a reporter are okay passing on. See.
Thank you. Ms. Fiona, please state your name for the record.
Michelle Liano,
Where are you currently employed?
the New Mexico Environment Department.
How long have you been with the department?
A little over a year.
What is your current position with the department?
I'm the director of the Environmental Protection Division.
Could you please briefly describe your duties?
Yes, as director, I oversee policy initiatives. I work closely with the secretary for the Environment Department, the deputy secretaries, and other environmental department leadership. And we develop strategies, policies, and manage the budget and provide direction for the bureaus that we oversee.
Thank you. Would you like to start with slide 30 to assist with your live testimony?
Yes, thank you.
Excuse me, what slide? 30.
I believe it's up. So would the proposed fee updates fulfill the department's strategic plans?
Yes.
How would they do this?
The environmental secretary and our leadership team over the past several years has developed strategic plans based on the fiscal years that we're entering into. For the fiscal year 2024 strategic plan at EIB 23-75, Exhibit 34, the Environmental Protection Division includes the following program goal: protect and promote public and environmental health by preventing unnecessary radiation exposure through effective licensing, registration, inspection, special investigations, and enforcement. To achieve this program goal, we recognize the need for a specific action to achieve that goal. And that specific action is to build and retain a skilled and trained team of radiation specialists, including license writers, environmental analysts, enforcement specialists, and inspectors to ensure timely license and registration issuance and compliance with radiation regulations.
And how about for the current year's strategic plan? How would these proposed rules fit in this plan?
So moving into fiscal year 2025 for the strategic plan that we've put together, we really, as an agency, made it an agency-wide objective And this is seen in our fiscal year 25 strategic plan at Environmental Improvement Board 23-25, Exhibit 35. We really have presented an agency-wide objective across all divisions and bureaus to, quote, ensure robust staffing and resources to improve the implementation of our mission, end quote. Again, that's at Exhibit 35. Moreover, for our division specifically in the Environmental Protection Division, we not only incorporate that goal into our own goals, and the goals from fiscal year 2024 strategic plan, but we also have a specific directive to, quote, ensure its programs, that means our programs in the division, to have sufficient funding via fee increases to support our program objectives. And that is at EIB 23-75, Exhibit 35.
Thank you. Let's proceed with slides 32 and 33.
I'd like to stress that the proposed rule changes here today will fulfill these strategic plans and as a practical matter will enable us to achieve our program goals and objectives. In order to prevent unnecessary radiation exposure through effective licensing, registration, inspection, special investigations, and enforcement, the Radiation Control Bureau must be able to financially support the skilled and trained teams of specialists necessary to conduct this work statewide for its radiation protection program. By aligning the fees in 20.3.16 NMAC with the NRC fiscal year 2021 fees, the state of New Mexico's fees would reflect the actual cost of reviewing, issuing, and administering a license. Over the past several years, the Radiation Control Bureau has attempted to maximize how far a dollar can go with its outdated fees. And us as a department, the New Mexico Environment Department, we've sought special appropriations from the New Mexico legislature to fill in gaps as a patchwork. However, this is not a sustainable model for the radiation protection program, and this program needs to be updated through these proposed fees to meet the fast-paced present-day demands.
Let's continue, Ms. Miano.
For these reasons, I'd like to conclude and state that we ask the board to keep regulation local and support the proposed rule changes so that the radiation protection program in our Radiation Control Bureau in the state of New Mexico can receive predictable, stable, and adequate funding to support its critical work and services throughout all corners of the state of New Mexico to protect our residents and our environment.
Thank you. That concludes the direct examination of department's witnesses.
Okay, thank you. We've heard from 3 technical witnesses from the department, Mr. Rodriguez, Mr. Ortiz, and Ms. Miano. Does Nicholas R. Maxwell wish to cross-examine these witnesses? Mr. Maxwell?
Hearing officer, I will pose approximately 6 questions, and I invite any panel member who feels most qualified to address each question in response. First, is it correct that on February 25th, 2024, the NRC submitted a letter to New Mexico endorsing the proposed fee adjustments for the agreement state program?
Ms. Miano, would you like to answer?
Yes.
My second question, to anybody's knowledge, was the NRC's letter expressing support ever made accessible to the public through the department's smart comment system?
Ms. Miano? Ms. Miano, if you know, or you can ask if the viewership knows.
I don't know, but Bureau Chief Rodriguez, do you know?
Mr. Maxwell, thank you for your question. So the Bureau received the letter this week. My apologies, time seems to stand still at moments. The letter has not been made available via smart comment.
Thank you. My third question. To anyone's knowledge, is it true the NRC's letter was first made available to the public on the NMED's Docketed Matters page last night?
Ms. Miano, would you like to address that question?
That is my understanding.
My fourth question. In the letter, does the NRC refer to two specific Integrated Materials Performance Evaluation Program reviews, or IMPEP review, documents from 2021 found within the NRC's document database that underscore specifically the importance of New Mexico addressing staffing strategy recommendations?
Yes.
Thank you. My fifth question, given these references to the 2017 and 2021 IMPEP review documents, NRC's letter, can one panel member elaborate on the significance of these staffing strategy recommendations for the New Mexico Agreement State Program?
Ms. Miano, would you like to answer?
I'm gonna defer to Bureau Chief Rodriguez's response.
Mr. Maxwell, thank you for your question. So the IMPEP process is comprised of various program elements. One of the program elements is staffing, training, retention, recruitment. And so the USNRC highlights that when there is a vacancies occur and there are lapses in time when we have staff and when we don't have staff. So what they do is they make recommendations based on their findings in this indicator to amplify the need for proper staff training, for an adequately funded program in support of this. So yes, in the IMPEP, it has been a continual challenge for the Radiation Control Bureau due to resource restrictions and the fact that people in this, it is difficult to find, recruit, and retain people with this expertise. So the challenge is twofold, and that was documented in the final IMPEP reports that were issued.
Thank you. I believe my last question. Considering the NRC's letter was submitted on February 20th, 2024, but was not made public until last night on the NMED Docketed Matters page, would the panel concur that the public did not have these 2 days in between submission and posting prior to today's hearing for this review?
Ms. Miano.
I would say that we made this available as soon as practicable after we received it. The letter stated February 25th.
Thank you. That's all the questions I have today.
Okay, thank you, Mr. Maxwell. Does the board have questions of or wish to cross-examine these witnesses? Member Bitzer.
So had this letter not been forthcoming, would it have affected our ability to move forward at all?
No.
Other questions from board members?
Actually, if Bill wants to take a turn, I you have a straight question.
Member Bitzer.
I'm just gonna run robin here a bit. I've got a question. So I heard earlier about the Atomic Energy Commission. That's the same thing as the NRC?
One moment, we're going to get the microphone to the witness who can answer.
Or Bureau Chief Rodriguez, do you mind answering that one?
So the atomic energy, excuse me, sorry. Hearing Officer Honker, Chair Sweeney, Member Bitzer, thank you for your question. So the Atomic Energy Commission is what the rules that the NRC follows, right? So the NRC is part of the Atomic Energy Commission. So like we are part of the New Mexico Environment Department, they're part of that, and that was developed then that it guides the departments that oversee materials, reactors, etc.
Thank you. Do you all regulate radon at all? It's a naturally occurring source.
So I will take that question. Thank you, Member Bitzer, for the question. So we do not regulate radon, but we administer an outreach program through the state indoor radon grant provided through the EPA. So we provide educational materials. We do stand-ups at environmental outreach fairs, health fairs, and we provide radon test kits, and we direct individuals to subject matter experts. We don't regulate that currently.
Along that same line, thank you. Smoke alarms. My recollection is that those little suckers have a radiation source in them, and I don't know if it's urban legend or not, but somebody went around and collected enough of them at one point, warehoused them all to the point where it became an actual health hazard. Is that something you all touch on?
So, Member Bitzer, that is a great question and a great observation. So, smoke detectors do contain an americium-241 source that is exempt. So those smoke detectors are distributed under exempt quantity license, which is only issuable by the US NRC. So yes, in fact, you can accumulate enough of them to cause an issue, but that would mean, excuse me, that you'd have to separate the source from the device, which would then terminate the device's ability to be considered exempt. Anytime a source is separated from a device, the exempt quantity exemption no longer applies. So we have service providers in the state of New Mexico that are qualified to recover, handle, and dispose of said devices.
That's all I got.
Okay, do any other board members have questions on witnesses?
I have a lot. Sorry. I'm wondering about a breakdown before we get into that, or do you want to go? How long do you want to go?
Well, in the interest of continuity, I'd like to keep going for another 30 minutes or so and see where we are. So go ahead.
Did you bring the microphone?
Yeah. Tear it out. For any one of the witnesses, I have a lot of questions about your finances and how you expect the proposed rules to shore those. And so how much do you anticipate to collect in fees for the radiation protection program? How much do you collect now? And how much do you anticipate collecting under the proposed rules?
I'd like to ask the bureau chief to answer.
Member Ely, thank you for your question. So currently our anticipated revenue, so anticipated and what we've actually received on an annual basis differ. So our anticipated revenue based on the current radioactive materials licenses we have is approximately 908,000. FY24, FY25, our anticipated revenue with the proration is 1.8 million. Again, all things align and people don't claim small entity. We don't lose licensees, etc. Right now, that 908 is based on the current amount of licensees we have in the state. This changes. This is dynamic and it changes on a daily basis. It can increase, it increases or decreases by 5 to 10 a year. In FY26, the anticipated revenue is approximately 3.8 million. Again, these are all estimates because through the small entity exemptions, we've provided relief and for licensees so that they have opportunities to exercise that. In addition, we've increased the allowable amounts of revenue that a company can earn. It went from 5 million to 7 million for manufacturers, and for up to 8 million for manufacturers and up to 7 million for non-manufacturing licensees. What do I mean by manufacturing? I mean individuals that create devices that they resell. So that's the difference.
So you anticipate maybe a little more than 3 times the amount of fees being collected in 2026 than you currently collect now.
That is correct.
And how do you know that's enough to cover the program or more than you need? And perhaps have you drilled down to how many hours it takes to issue to process an application and maintain that application? Are there numbers that align, or are you just lining up with what the NRC is doing?
So we've done a little bit of both. We've drilled down, but in the drilling down, it has become apparent to us that it is difficult to categorize these license actions because, as Mr. Ortiz discussed earlier, the licensing actions have become more complex with emerging technologies, with fusion technologies. So every time an action is proposed, you have to take into considerations the dynamic of the changing field, the training required, not only for the individuals handling the material, for the physicians, for the medical physicists, what is required if the licensee decides to terminate. We have decommissioning, there's termination requirements. So we've determined that the approach that we're taking will adequately sustain the Radiation Control Bureau now and going forward. As a mechanism, the CPI has been instituted to continue the furtherance of that, so we can continue to increase over time as costs increase, staff, inflation, those things that we anticipate will be going up in the future, as they have done and we've demonstrated historically.
And I'd like to add to that, Chair Sweeney, members of the board. In addition to increasing complexity of the licenses, as Bureau Chief Rodriguez is describing, we also have requirements under the legislative council service that we're marked on. And for compliance and enforcement for the past 3 fiscal years, our numbers are admittedly abysmal on all of our compliance and enforcement. For the last numbers we have for fiscal year 22, we inspected our percentage of ionizing and non-ionizing radiation sources were 12.6. For fiscal year 2023, they were at 15%. We are in the red when it comes to those marks, and that is not where we want to be as a bureau tasked with protecting human health and the environment. We want to be meeting all of that and be at 100% inspection rate and make sure that we have the staff in order to get those inspections done. We've done planning as far as the build out of what we need to do for the program, staff wise. Both Bureau Chief Rodriguez and Program Manager Ortiz and other members of the staff have met with me personally and my Deputy Care Director, Donna Bahar, in order to analyze and evaluate how many full-time employees we need to meet the objectives that not only the legislature requires of us, but that the residents of New Mexico expect from us. They expect to have, safe exposures to radiation. They expect to have an environment safe from these kinds of exposures. And so we are very much mapping out what we need to do in order to not only fill the vacancies we have, but expand our units within the Radiation Control Bureau to meet those expectations.
That's great. So my concern is that you've been underfunded for years, and then now you get so much more. Are you going to build up a revenue that's primed for being rated in a few years? Bank account that is too much. That's not a good thing either. Now, I see that you have to go before the RTAC on an annual basis to report your income fees, report on the fees that you're collecting. But it doesn't say anything about adjusting those fees based on the projected needs of the program. Would that be part of that annual review?
Bureau Chief Rodriguez, would you like to speak to the RTAC?
Member Ely, thank you for your question. So historically, we have not done that because the rules have only required us to report out on the revenues received from radioactive materials. I will say that is a great comment and something to take under consideration. And I think that in discussion with Michael Ortiz, I think that would be a not only appropriate, but a viable way to communicate and to ensure that the revenues that we are receiving are continue to be adequate into the foreseeable future.
Member Chair Sweeney, Member Ely, I'd also like to add that the increase of fees that we're talking about is going to provide a stable revenue source for us to expand. We cannot staff up currently with our unpredictable and inadequate funding. We will continually, evaluate money and funding needs, how the Bureau and the Radiation Protection Program is using those fees, and we can draft rules and adjust if necessary.
One more question before I stop for the moment. The Radiation Protection Act does not allow you to collect fees, X-ray equipment, medical, dental, and veterinary facilities. Not sure how they got out of it, but you're licensing those facilities, you're inspecting those facilities, and those facilities are not covering the cost of the program. Seems to me that fees like this are subsidizing the vets, the dentists, and the medical facilities. Is there an effort to go back to the legislature to change that statute?
Chair Sweeney, Member Gilly, yes.
Did you go back this last session?
We did not, but I've elevated this issue to the secretary, and we are expecting to review that exact issue in preparation for the upcoming 60-day.
Thank you. That's all to me.
Do any of the other board members have questions for these technical witnesses? Let me proceed with cross-examination from the public and see if there are any members of the public that would like to cross-examine these three witnesses. Ms. Jones, are you seeing anyone on the platform?
No, Mr. Hearing Officer, no one's in the chat.
Okay. All right, so I think that concludes cross-examination of the department's witnesses. Would this be a good time to take a lunch break? And we will reconvene with Mr. Maxwell's testimony. Is an hour adequate, or? Think so?
Yeah.
Well, let's say we will reconvene at 1:40. That would give us a little over an hour. Is that agreeable to everybody? Okay, all right, we are adjourned until 1:40. We will reconvene at that point with Mr. Maxwell.
All right, you're live.
Did you do shares?
Yeah, Chair Sweeney is missing, but we have a forum, so I would suggest we go ahead. Is Mr. Maxwell on? Mr. Maxwell on?
Can you hear me?
I can see it.
There he is.
Can't hear you, Mr. Maxwell.
Can I be heard?
Oh, now we got you. We got you. Okay, we have heard the technical testimony from NMED and cross-examination. So we will now hear from Nicholas R. Maxwell. Does Mr. Maxwell wish to make an opening statement?
Hearing officer, I have nothing for the record today. Thank you.
Okay, thank you, Mr. Maxwell. We will now hear non-technical testimony and take written statements from members of the public. Any testimony must be limited to proposed amendments. Board is unable to take any testimony unrelated to the proposed amendments. Ms. Jones, do we have any members of the public who have asked to provide testimony?
No, sir, there's no one in the chat or that has reached out to me via email to make any comments or testimony.
Okay. So I believe we've been through all the witnesses. Is there any rebuttal testimony that Ms. Chai, your witnesses would have?
The department does not have rebuttal testimony.
Okay. All right, and any person who testifies or wishes to make a brief closing argument may do so now in the same order as the direct testimony. We'll start with the petitioner. Any closing statements?
Thank you, Hearing Officer Hunter. And that was just briefly, the witnesses for the department have testified about the very great need for these proposed rule changes and the fees that would help them sustain and support and solidify the radiation protection program. The alternative to having an effective program that is underfunded as it is currently would be for the NRC to take the program, and then all the fees collected would go out of state to the NRC. And licensees would be charged the FY. At this point, it's federal fiscal year 23 or 24, these which would be higher than what the Bureau was proposing that the board adopt. So for the reasons that the witnesses have identified, we would ask the board to please adopt these rules in their entirety as proposed.
Thank you, Ms. Chai. Mr. Maxwell, do you have any sort of closing statement for us?
Hearing office, no closing statement today.
All right, I would like to thank the board and everyone present for their participation today. We did have a quorum of board members here, and the hearing notice indicated that this decision might be made at the conclusion of the hearing. Is there any objection to me closing the hearing record as of now? Mr. Maxwell?
You may be getting to this in a minute. I'd just like to suggest and recommend that we allow for comments to be submitted for at least 2 days. Thank you.
Okay. And what is your rationale for that?
My rationale is based on the fact that the NRC letter had been given to the department, and there was a passage of about 2 days where the public should have been provided this and allowed to inspect it on the website. And I don't find a justifiable reason for why it wasn't. Thank you.
Okay, is there any comment from the petitioner on potentially leaving the record open for a few days?
Could you, we adjourn for 2 minutes while I'm discussing with my, we adjourn for 2 minutes while I discuss it with witnesses.
Okay, let's take a 2-minute recess and go on for 2 minutes. Let me ask the petitioner if you have any comments on the request to extend the hearing record for 2 days.
Hearing officer, board. These rule changes have been overdue for a long time, for the greater part of 22 years. And as mentioned in the public notice, we were hoping for a decision at the conclusion of the hearing. The reference letter was actually not directly addressed to the Bureau. It was addressed to the board chair. And it consisted of public comment. And our understanding of the procedures are that it was submitted in the regular course of business by the conclusion of the hearing. And that's the rules allow for public comments to be received through the conclusion of the hearing. It looks like Mr. Request has had a chance to obtain the reports referenced in the NRC letter because they're available publicly online. And he seems to have asked the witnesses questions based on the reports, and he could have asked more questions on cross-examination. We believe that there has been enough time between posting that letter and reviewing it, and the board allowed the agenda items to be switched to provide even some more time. But we believe that the letter and the discussion of the adequate that the record not be so that they can decision proposals.
Thank you. Let's try. Do any of the board members have any comments on this issue? Vice Chair Keating.
Yes, thank you. And I'd just like to thank Mr. Maxwell for being considerate of making sure that public comment is given proper consideration and is followed in all aspects. And I read this letter a few days ago, and it's a letter basically that came in as public comment and is in support, or it's a positive letter about the rules that are being presented to us. But I don't see where the public could make a comment in this particular letter and change have any sort of substantive change to, sorry, I'm muddling words here, but having sort of change to the actual rules that have been presented. And so I think whether this letter came or didn't come, then it wouldn't change for what we had seen and made comment or decision on. So I don't think the record needs to stay open for public comments on this letter.
Thank you, Vice Chair. Any other comments from board members? Member Bitzer.
I just want to say I concur.
Okay. So as hearing officer, I'm going to deny the request for the hearing record to stay open. I agree with my two fellow board members. This seems like a straightforward letter that came in support of the proposed revisions, came in as public comment, and I think any members of the public have or anyone who has the record of the hearings has had this since last evening. So I'm going to deny an extension of the comment period, and I'm going to close the record of this public hearing right now. So the time is 2 o'clock. And we'll conclude the hearing at that point and go back on the agenda for the board.
She didn't mention the
All right, we have word that Chair Sweeney is on the way back. So we will just hold on for a minute or two to get back on the agenda.
Hey, this is Mr. Maxwell. I just really quickly like to object to the denial. That's not my wish. Thank you.
Your objection is noted, Mr. Maxwell. So Chair, I've posted the hearing record, and so we're back on the agenda for the
Wonderful. So now that the rules hearing is concluded, if the board elects to deliberate immediately, I'm wanting to see if we want to here. See some yeses. So if the board elects to deliberate immediately, the board will immediately deliberate to make a decision on the proposed amendments. If, while deliberating, the board determines that additional testimony or documentary evidence is necessary for a proper decision on the proposed amendments, the board may, consistent with the process requirements, reopen the hearing for such additional evidence only. So with that, I think looks like the consensus of the board to deliberate. So I would like at this point, I know we've heard testimony, we have the documents on record, as well as what we heard this morning and the various questions that members asked earlier. Is there any discussion before we start looking for motions? I look to the fellow members. Yes, Member Garcia.
Thank you, Madam Chair. Just wanted to thank the department for a great presentation and appreciate the information provided and the matrix provided, crosswalk, et cetera. That made it a lot easier to understand all the changes proposed. And generally speaking from the presentation, it seems appropriate at this time to increase the fees since they haven't been increased since 2002. And it seems reasonable to do that. Their presentation on the reasons for the various fee changes made sense and were compelling to me. So in general, I support the changes or the amendments to the rule.
Thank you for your comments. Member Garcia, is there any other discussion? Member Ely?
Yeah, I just also want to note that there were no public comments in opposition, which is, in my experience, kind of rare when it comes to a fee increase. And so, maybe it was some great outreach and discussions with the public about what to expect. Maybe it's because it's been 22 years that there is no opposition. It makes me feel better about moving forward with these proposed rules.
Thank you, Member Ely. Yes, Member Bitzer.
Harken back to a few years ago when we were considering changes to the fee structure for toxic waste permits. And I objected to the idea that there would be a cost of living adjustment built in to a price index of whatever we were basing it on. And because there was no inflation in those days, and of course, the fact that it comes from inflation, so now I feel like an idiot for objecting to that. So lesson learned in my world, but maybe. But it sort of it diminished our authority to have them need to come back to us again for a later bond. But that's an awkward, cumbersome process. Inflation is pernicious these days. So, but yeah, I'm 100% happy with this.
Thank you for that, Member Bitzer. Is there any other comments, discussion? I would just like to share, I was thinking about you, Member Bitzer, when I read the increase there in the materials submitted, and like you said, Member Ely, there was no opposition. So I was also surprised there wasn't opposition or any, and I think also looking at the documents and looking at the various outreach that the department did, I think that helped. That process helps, right? You get engagement from interested parties, stakeholders that will be impacted by these rules, and impacted by any revisions or amendments. So that's a much to encourage that process. And sometimes it does, to very point, it does help on this part of the process. So I just wanted to highlight that and thank you for that work as well. With that, if there's no other comments, would love to look to members of the board, see if anybody would like to propose a motion. We've had some discussion. Yes, Member Ely.
So I propose that we move forward with an adoption of the repeal and replace of 20.3.16 NMAC as presented to the board today for the reasons provided in testimony in the documents submitted to the board.
Thank you, Member Ely.
Second that.
Thank you, Member Bitzer, for your second. Now that we have a motion on the floor, Is there any further discussion regarding this motion? If not, I would look to Ms. Jones. Would you please do a roll call vote? Before you do, is that motion sufficient? Just wanted to do a double check on that. Ms. Jones?
Vote on the motion to adopt the rules as presented. Member Bitzer, how do you vote?
I vote yes.
And member Ely?
Yes.
Garcia?
Yes.
Member Hawker?
Yes.
And Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
The motion passes.
Thank you, Ms. Jones. And I just want to thank again the department as well as the guests online for your participation in this process. As Member Garcia mentioned earlier, the engagement through these processes is much encouraged, and so that we make sure we go through all of those protocols and appropriate procedures. So thank you for engaging in the process. And with that, I hope you have a wonderful rest of the day. Thank you. Okay.
Yeah, I couldn't hustle myself.
Thank you.
All right. With that, with that, thank you, members of the board. Thank you, Member Garcia and Member Humper, for both serving as hearing officers today, for your service and doing this preparation. And thank you for being here today. Appreciate your support. And
Thank you for making it easier for me. Appreciate it.
You're welcome. And with that, fellow board members, we're on agenda item number 8, which is discussion and approval of resolution. And I'll turn it over to our board counsel.
Thank you, Madam Chair. So everyone should have gotten a copy of the proposed 2024 owner. You will see it is shorter than what you've had in the past, and it's intentional to make it easier for both the public to read as well as the boards. It still contains all of the requirements to comply with OMA. Just trying to make it a little bit more streamlined. This is also something that my office rolled out this year. We're going to have every board and commission that we represent have a almost identical form of resolution. So it's been updated. If you have any questions, please let me know. But this looks very similar to probably what we've seen. No new information, just like the year.
Thank you, Ms. Bowen. Is there any questions on this matter from our board members? All right. So we're, I guess, we're at the point here. If there's no questions or additional discussion, we have a resolution on the table. Is there a motion? Member Garcia.
Thank you. Thank you, Madam Chair. I move that we approve the Open Meetings Act resolution as presented by council.
I'll second.
Second. Thank you, Member Garcia. Thank you, Member Humber, for your second. Any further discussion on the motion on the floor? No. And with that, Ms. Jones, would you please do a roll call vote on the motion on the floor?
Yes, the motion to accept the 2024 Open Meetings Act resolution. Member Bitzer, how do you vote?
I vote yes.
And member Ely?
Yes.
Member Garcia?
Yes.
Member Hawker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
Motion passes.
Thank you, Ms. Jones. Appreciate that. With that, we're on agenda item number 9, the next meeting and upcoming matters. I think Ms. Jones and legal counsel and go over. I know we have some meetings coming up. Can you remind us on those milestones?
Yes. Our next meeting is March 22nd. And we agreed that we would hold the hearing on the motion to stay in EIB 2356 with Felicia Orth serving as the appointed hearing officer, and she has agreed to do so.
Great. Wonderful. And that will be March 22nd at 9 a.m. Okay.
Do we know where yet?
Yeah, great questions. To get on where?
Yes, it'll be here at Durham House. I believe it'll be in room 321.
Wonderful. And then in the meantime, I know Ms. Jones and I and legal counsel will coordinate a meeting notice that will make sure we'll firm that up and confirm with the public as well, so that they're aware of a time and meeting dates as well. So if anything changes, just noting that, because I know that's happened in the past where we changed rooms. But with that, is there anything else, Ms. Legal Counsel? Okay. If not, we're on item number 10, adjournment.
I will move, we adjourn.
I will second that.
Thank you, Member Hunker and Vice Chair Trujillo. Ms. Jones, if there's no other discussion, Ms. Jones, would you please do a roll call vote on Member Hunker's motion to adjourn?
Yes. Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes.
And Dr. Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Member Sweeney?
Yes.
We were adjourned.
Thank you, Ms. Jones. We have adjournment at 2:15 p.m. Thank you, everybody on the line, and appreciate your engagement today.